Hey guys, it is March 13th, 2026, and today in front of the Georgia Senate Special Committee on Investigations, we're going to listen to the testimony of Jeff DiSantis and Nathan Wade. I actually forgot this was happening today, and I saw a lot of people popping up covering Nathan Wade, and I also realized Jeff DiSantis testified earlier today. So I want to start from the beginning. I want to watch the whole thing. Personally, I think his testimony would be important here. We've heard his name a lot following this whole Fani Willis saga. He's the deputy district attorney. He's in the media relations division. I call him the media or PR guy for Fani. Quick summary here so you know who we're going to be looking from. I think a lot of people know Nathan Wade, but might not know so much about Jeff DiSantis. So Jeff is the deputy district attorney overseeing the media relations unit. In that role, he's responsible for keeping the public informed of the work that the district attorney and the issues the office is handling that are of importance to the people of Fulton County. Jeff is an attorney whose experience includes working in media relations for government officials and political candidates. He served on the government staff of the United States Senator Zell Miller and Georgia Attorney General Thurbert Baker, where he served as the primary media contact for the office. For a year after law school, he served as an intern in the White House Domestic Policy Council during President Bill Clinton's term. Jeff has also worked for candidates in 30 states running for a variety of offices, including President of the United States Senator, Governor, United States Representative, this is a laundry list, Attorney General, District Attorney, and Mayor, as well as for a national political party committee. He served as campaign manager, media consultant, pollster, press spokesman, research director, and policy advisor. And a lot of these came into play, things that he's done with Fani Willis and her office. He also served as the executive director of the Democratic Party of Georgia. A private legal practice, he represented elected office holders, candidates, party committees, and advocacy organizations before regulatory and enforcement agencies, including the Federal Election Commission, the U.S. House Ethics Committee, the Internal Revenue Service, the Georgia Government Transparency and Campaign Finance Commission, and local bodies. He also handled matters for entities regulated by U.S. foreign and international law related to international trade, transnational financial transactions, and overseas offices and employees. He's a graduate of Emory and University of Georgia. So we're going to start. It's his testimony that kicks off the day. So I know everybody coming in here might be like, well, where's Nathan Wade? And don't be surprised, you guys. I mean, I really think some of the stuff Jeff DiSantis is going to testify to. Remember, this Senate committee, this special investigation, is really looking into alleged misconduct and misuse of taxpayer funds in Fulton County by DA Fani Willis and her office. And of course, a key part of that investigation is what was done in and around and before and after the Trump 2020 election case. So, speaking of money, if there's this idea that prosecuting President Trump or presidential candidate Trump could have been good for press, good for media relations, Jeff DiSantis might have some very interesting testimony. They might ask him some very interesting questions. So we're going to get into it. I have the volume boosted here. There are no captions available, so sorry about that. But you might be able to turn them on this specific stream. So here we go, you guys. Oh, I guess it starts in a little. Let's zoom forward. There we go.
Business first. But this is a meeting of the Senate Subcommittee on Special Investigations. Chairman Cowsert essentially divided our committee work as we near the end of the legislative session here, and this subcommittee has been formed to focus on the election interference case and the work really that the committee was originally started for. And then Chairman Cowsert, you've been having the other committee kind of lead on some of the legislation that's come out of that process. I know you've dropped a number of pieces of legislation already that are in flight and in process. But this is the second meeting of this subcommittee, and I'd like Leader Jones and Chairman Cowsert, if you guys can just review the minutes, pretty simple minutes from our last meeting. We'd love to entertain a motion to get that taken care of.
straightforward. I would move that the minutes be approved as stated.
We have a motion and a second. All those in favor, please signify by saying aye.
Aye.
All right, and those minutes are approved. Thank you. We're going to have a two-part committee meeting today. We have two witnesses that are here to testify. The first is Mr. Jeff DiSantis. Mr. DiSantis, thank you for being with us. I know you've worked with us on finding the time and are here via our subpoena, but you've been cooperative in helping us find the time and to testify, and we do appreciate that. And with that, we'll go ahead and swear you in, and then, yes, sir. This is a subcommittee.
You still don't have a form. We're subpoenaed to appear before the committee, and you don't have a form to transact business. It's not inquisition, where you have one or two members just question a witness. The public has a right for the full committee. You maybe need to subpoena them.
I think our rules allow
Yeah, well-
testimony with as few as two.
It's not what the subpoena is issued for. It is issued for testimony before the committee.
Oh, man.
I mean, if the members of the committee are not interested enough, and it's just one or two that are running statewide that want to raise money, and the rest of them don't want to be here, then I object to going forward, and I want the record to so show.
All right, we'll defer we'll give a few minutes for our council to review committee rules, as well as the, you can speak into 7 there. This is Mr. Kerry Miller. I believe some of you folks know who he is, but he is standing in for Mr. Belenfante today, who is in court on a different matter.
Mr. Chairman, I understand the objection that the governor has stated here. At the present time, though, the objection that he is offering is not one that is subject to the witness having standing to assert with respect to the committee business. My understanding of the rules and procedures, we can proceed with less than a quorum for the purpose of information gathering, so long as you're not voting on a action item or recommendation out of the committee.
I'd like that rule read into the record. And what the subpoena says, we're not here voluntarily. We are here under a subpoena. So read into the record the subpoena for the witness and the...
So Roy Barnes, I'm going to try to toggle the volume up when Roy Barnes talks and cut it back down before those that are mic'd up talk, because I know it's going to be an imbalance. Roy Barnes is not mic'd up. This is gold. This is why we've got to go back and watch it. Forget everything I said about Jeff DiSantis. We've got to watch this for Roy Barnes. Keisha's already like, this guy. But he's like, I don't think this subpoena gives you the power to do this type of questioning. I want you to read the subpoena into the record. And so here we go. I think this is going to be a time. Also, I want to stop to give a special shout out. I think Sunday is your birthday, right? Grandma Ninja. Right? Sunday? I think that's what I had on my calendar. I gotta check. But we'll celebrate all weekend long, of course. So happy birthday to Grandma Ninja. Hope you have a good one. And we've got some Jeff DiSantis and Roy Barnes and Nathan Wade. And I don't know Nathan Wade's counsel's name yet, but we're going to get there.
And also the rules of the Senate, not of the subcommittee, because it'd be the Senate rules that apply.
All right, they're going to look at the committee rules.
Governor Barnes, just to make sure we're looking at the same subpoena here, because I'm reading the subpoena myself. Set forth below to testify at a public meeting of the subcommittee of the Senate Special Committee on Investigations, correct?
Correct.
Okay.
But there's not a quorum of the subcommittee.
Mr. Chairman, I don't believe that there is a set of rules specific to the subcommittee and establishing a quorum for said subcommittee. There's 4 members of the subcommittee.
Yeah, that's correct.
And 3/4 of those members are here. Thank you.
When was the subcommittee approved? It was approved by the Senate.
Back in,
I think he's asking when was it approved by the subcommittee with the 4 members. That was quiet.
if I'm recognized, subcommittee was
Yeah, you're
formed
recognized.
back in December, as I recall. The rules of the Senate Committee on Investigations say a quorum of the committee shall be 5 members. That's of the full committee. For the purpose of taking testimony and receiving evidence, a quorum of 2 members is required. That, of course, is the purpose of today's meeting. There's no votes to be taken today, so as long as we had 2 members here and we have 3 members of the committee and 3 out of the 4 members of the subcommittee that are present here today.
I stand on the objection. The Senate rules apply. Some rules that you make up as you go by.
Counselor, how do you advise that we proceed here?
Governor Barnes, is your client refusing to provide testimony at this juncture?
We're here.
Great.
Proceed with the question.
We'll do that. All right. Mr.
Testimony on matters is set forth in the resolution.
Mr. DeSantis, we'd just love if you give us some of your background, specific as it relates to your work in the district attorney's office, how you came to be in your current role, if your current role was your original role, and what your duties are therein.
My current role is my original role. Well, I started on, I actually remember well, because I was watching, it was COVID, and the first day orientation was remote, and I was watching the news on January 6, 2021, which was an unfortunate day, as you recall, while I was getting oriented. But so that was my first day in the office. I've had the same job since then. And my duties are, I primarily deal with, well, several things. Obviously, as a deputy district attorney, I do anything I'm assigned to do by the district attorney. I deal with the press, which we get a large amount of press. I deal with other special projects as assigned, writing, research, that type of thing.
How were you recruited, hired for the role?
I knew Ms. Willis. I worked for her campaign in 2020 as a consultant, and we actually shared office space in Midtown, knew each other there, and she asked me to do it. I originally said no. It wasn't really in my life plan. I'd worked in government, worked in the State Attorney General's office in the U.S. Senate for Senator Zell Miller, a couple other roles that led me to think my time in government was over, but she convinced me to come help. It was a time that the district attorney's office was challenged, not just because of COVID and the shutdown of the courts, but also because of just the nature of the management that preceded her. It was a difficult time, and so I agreed to come on. Didn't know how long I'd stay. I will say it has been, for all the places I've worked, the most rewarding job I've had, as far as feeling like you go to work and actually do something to help the community, make it safer, help people stay out of trouble. Not just prosecution, but the other programs that go on there are extensive, and REACH program, record restriction, pre-indictment diversion. So it's been a very rewarding job, and I've been there longer than I thought, but I've enjoyed every minute of it and felt it was a very worthwhile endeavor.
So the pre-indictment diversion program, they built this huge facility, and there's been some investigative journalism recently that's looking into it, and it's operating at a fraction of the capacity that it could and should be. But a ton of money went into it. So that's interesting. I'll grab that link and drop it in the chat. Maybe we could do another stream on that.
Thank you. I did get sidetracked, and I apologize for this. We did not swear you in. I was starting to do that, and then we got cut off. So if you don't mind raising your right hand.
Sure did.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yeah, I do.
Thank you. Going back to your role, you said you're deputy district attorney. You said you kind of focus on some media work as well. Are those two separate titles? Or are they?
No. It's deputy district attorney. I believe she calls it media and strategy, and I deal with a fair amount of press inquiries. We probably get more press in that office than I would put up against any government office in the state of Georgia. It's, obviously the press is very interested in what we do. It's crime, violence, efforts to curtail it, court cases, verdicts, et cetera, et cetera. So we have a lot of incoming. When I was in the Attorney General's office, having an attorney deal with press can be helpful because you can explain to reporters some concepts that might be a little more complicated than what they normally cover. Also, you have a little bit better understanding of where the line is on what you can say and what you can't say, depending on the stage of a case. So she wanted an attorney to do that job. I know she talked to some folks, including one at my recommendation, but asked me to do it based on our work previously, and I agreed to do it, and I'm glad I did.
And you're still a bar attorney, is that correct?
Yes.
Okay. Have you practiced law as a full-time endeavor before you got into campaign work and now working at the DA's office?
Well, I have done both legal practice and consulting, which has involved some consulting with campaigns, some consulting with other types of organizations, but have practiced law off and on since 1994.
Okay. What was your role in the campaign?
Consultant.
Wait a minute, what does this got to do with special? He's an employee, so it doesn't do anything.
Yeah, just trying to lay background here, Governor.
I understand that, but we're here to testify as to the issues on the hiring of special district attorneys. That's the purpose of this memo. And he is an employee. He is not a special district attorney. So I'll let him go ahead, but this is just not something we can just go into because you got him here.
No, this is going to relate to the matter we're here to talk about.
That'll be pretty quick.
We'll get there.
Would you restate what you were asking?
What was your role in the campaign?
I'd say general consultant.
Okay.
I mean, she
had been asked to run for district attorney by people that were concerned about the condition of the office and what that meant for the community and public safety. We spoke about it. She asked me to help, and I was happy to do so. We didn't know each other well, but we knew each other a little bit, primarily from sharing office space.
And your current role is full-time with the DA's office and has been the entire duration? That's a W-2 role, not a contracted role? Is that correct?
I'm an employee.
Okay. We had testimony from Ms. Willis and just kind of general conversation in the committee around the hiring of the special assistant DA, Mr. Wade. Was he working on the campaign as well? I believe there was a transition team. Were you part of that transition team?
I was. No, I don't recall Mr. Wade working on a campaign. He may have been a donor or a volunteer fundraiser. I mean, you guys run for office. You know how campaigns are. You pull people in your life around you to help you raise money and reach out to the community. But I don't recall him being involved in the campaign. The first time I interacted with him was that volunteer committee that she put together of attorneys to help her interview the folks in the office who wanted to stay, as well as those who were outside but might want to join the initial administration.
Essentially in between the election and her swearing in, y'all were gearing up to
I don't remember the exact dates, but I recall it being late 2020.
Were there, and she testified to, obviously, in her opinion, the office, I think she would have described as a mess before she came in. She was trying to decide who she was going to keep, who she was going to get rid of, who she may bring in new. That's the type of transition work that you're
Yes,
referencing.
and it was an eye-opening experience. It was alarming. I will be blunt.
In terms of what y'all were stepping into.
Yes, the first person we interviewed was a very inexperienced lawyer who told us that she lost a carjacking case because she didn't know what she was doing. As a resident of the city of Atlanta and Fulton County, she walked out of the room and I was picking my jaw up off the floor.
Dang. Just that poor attorney
The
just got
the specific committee that you and Mr. Wade were a part of, was it an ad hoc committee? Was there a designated leader of the committee?
Well, the district attorney was the leader. I mean, she made ultimately the hiring decisions as she does to this day, and is very careful about who she hires for every role. We offered our thoughts on various folks that interviewed, whether they were appropriate to keep or bring on, or whether they were appropriate for the role they may have had.
Was there any discussion during that time? I believe that there was a search committee that was in place at some point relative to a special prosecutor for the Trump election interference case.
Wait just a minute. The Trump election interference case was not pending at the transition. He hadn't committed the crime yet.
According to the indictment alleges that the crime was committed back in November of 2020. And so this would fall in that window of that time frame.
But he hadn't made the call to Raffensperger. He still was encouraging him to take over the Capitol and have a coup. So the crime hadn't occurred yet.
Are you objecting to the question, or are you just kind of opining? Okay, what's the grounds of the objection?
The grounds for the objection is when you ask him that was there a interview or process to pick a prosecutor for the Trump interference case, the crime had not been committed yet. That didn't happen until 2021. That's the objection.
Just that's an objection to the form, Governor.
Objection to the form and also the relevance.
Mr. DiSantis, do you understand the question?
I want you to restate it.
Sure. I'll restate it, and it may be different from what I actually asked you, and maybe it'll lift his objection. Can you give me information about what you remember as your conversations as it related to any conversations you were part of with the committee, the transition team, as it related to hiring a special assistant district attorney?
There were none.
Okay.
Every person that appeared before the committee either was a current employee wishing to stay or a person outside the office, which is a much smaller group, wanting to join as an employee, as an ADA or deputy DA.
That's as it relates to the transition team.
That's the committee that was doing the interviews while she was district attorney-elect.
Got it. There was a search committee that was formed as it relates to the special assistant district attorney.
I'm not aware of a committee to do that.
Okay.
I'm not saying there wasn't one, but it wasn't something I was part of. If there wasn't, I never heard that there was a quote-unquote committee, like a formal committee of any sort.
Were you part of any meetings as it related to the hiring of a special assistant district attorney?
Is that something I should answer?
So that's an internal process. Internal process procedure of the office. I'm instructed not to answer.
I mean, we didn't state this up front. Governor Barnes, I don't know if you want to state it, but I've been instructed not to waive any privileges that exist in the office as a prosecuting office, legal office. So
I think the question was, did a conversation occur, not what were the contents of said conversation? That, to my understanding, was not within the privileged objection of deliberative process.
I'm sorry.
Are you still instructing the witness not to answer?
No, but that wasn't the question.
Okay.
The question was, were you present, participated in a committee choose the special prosecutor. So,
I'm not sure the difference between what you're.
Do you mind if I just ask a couple questions on?
I will say this, and I just checked with the governor, and you may recall, he testified that the district attorney had asked him to consider serving as special counsel, special prosecutor.
He being the governor? Yes.
Right.
Correct.
The 80th governor sitting next to me. And I was in that meeting. I have known the governor for a long time. He's a magnanimous guy. We worked against each other in 2 primaries that he won. I wasn't the candidate, but he put a pretty good whipping on Louis Massey in 1998, and Ferber Baker, my good friend, in 2010 that I also worked for. But he's a gentleman in addition to being an excellent lawyer. So I knew him, and so I was in the meeting. But beyond that, since that's been a waived point, since it's been testified in court, I'm not going to go into anything else. But I will restate what I stated earlier. I was not aware of any formal committee. I'm not saying there wasn't one, but I think you can conclude from me not being aware of it that I wasn't in the meetings.
Sure. And I do, just in being fair to you, if you do want to consult with Mr. Barnes, just be aware the microphone's off. If you want me to turn, or sorry, is on.
Yeah, that's okay.
And if you want me to
Yeah.
turn it off, I'm happy to do that.
I mean, that was an easy one because it's already been testified.
I just want to just so you're
okay,
aware.
that's true. And if there's something that comes up, can I turn it off?
You
or-
cannot. So if you
Okay.
ask me to,
All
I
right,
would be
go
more than
ahead.
happy to do that for you. So you were in a meeting with Mr. Barnes, and Mr. Barnes, we did discuss that in your presence last time. Were you in any other meetings? Were you in a meeting with Mr. Wade where it was discussed, where the idea of him coming on board as the special assistant district attorney was discussed?
when he can testify as to whether he was at a meeting.
Correct.
Any discussions?
Yeah, I won't get to that. I just want
Okay.
to try to establish.
I just want to make sure.
I think as a first step, we got to establish the basis if there's going to be a claim on it. So that's part of it.
That's it.
No, I was not. I don't know if there was a meeting, and if there was, I was not present for it.
Okay. Did you have any discussions with DA Willis about hiring Mr. Wade?
Don't answer that. The discussions
Don't
that
ask that.
he has internally on personnel or cases are matters of process and procedure and are matters that are not subject to the testimony. Privileged.
Counsel, is the objection as to any question relative to personnel? That's what I understand your objection is stated.
It is. It's not that whether, he can ask him whether he was present at a meeting, but not what was said. And the question is, I understand, were you present when there were discussions? And those discussions, you'd have to disclose whether there were discussions or not. Were you present at a meeting in which a decision was made, such and such? You can ask him.
The fact that discussions occurred, Mr. Chairman, correct me, I believe the question was, did you have a discussion regarding the hiring of Mr. Wade in this matter?
That is-
Whether the discussion occurred or not, you had a discussion generally. The contents of that discussion are separate. I believe that's an answerable question.
If that's an answerable question. Did you?
I don't recall discussing Mr. Wade serving as special counsel prior to being told that he was going to serve as special counsel.
And the original question was with Ms. Willis. Would you extend that to include with anyone? Do you not recall
Yes,
having
I
a
don't
conversation
recall.
with anyone?
I recall being told that the decision had been made. I do not recall
Wait
being.
just a
Okay.
minute. Let me tell both of y'all. Wait till he finishes the question, and then wait till he finishes the answer, because the testimony is going to be jumbled on the record. With
Absolutely.
She's one, so y'all are talking over each other.
Okay, sure.
Okay, go ahead.
You want to re-ask it?
Sure. Would you extend your answer that you were not part of any discussions with DA Willis relative to the hiring of Mr. Wade to essentially, were you part of a discussion with anyone, to your knowledge, prior to the hiring of Mr. Wade relative to the hiring of Mr. Wade?
I don't recall having any discussion about Mr. Wade or any other candidate actually being hired prior to being told that he had been chosen to do. To
With
fill
the exception
role.
of Mr. Barnes, which you...
With the exception of Mr.
Correct.
Barnes, yes.
Okay. I do want to ask you, one of the things that we talked about in the last meeting, and as we kind of look at our funding mechanisms for district attorneys' offices from the state, that is something that's been an active part of the conversation in this committee. Obviously, we fund them through PAC, and we are actually in the appropriations process today. There's a meeting happening right now. I want you to walk me through the hiring of critical mention, I should say the contracting with critical mention, the timing of that, as you recall it, and the purpose of it. If you were the lead on that, if somebody brought that to you, if you give us kind of just general background on that, then we've got some more specific
Sure,
questions.
sure. Well, I'll say, yes, it was my idea and part of my duties. I mean, I did take the time I knew you had mentioned that you wanted to talk about this, and I went through the open government portal that the state provides, and my colleague has a printout of this, and I can provide it to the committee.
We'd like to be included in the record that y'all are buying, the state of Georgia is buying critical mention to the governor. or its competitor, the Attorney General, everyone else, and so we'd like for it to be part of the record.
Yeah, and I'm honestly a little surprised that this has been such a controversy, but just looking at the list here, you got the Office of the Governor, this is 2025, Department of Transportation, Georgia Forestry Commission, World Congress Center, Augusta University, Georgia Gwinnett College, several units, 2024, same thing. And just going to what the governor said, competitors, there's TDIs, which is a competitor. The Attorney General's office has that in 2025. University of Georgia, Kennesaw State, Public Service Commission, Department of Public Health appears. Let me double check that. I have this list if you want it.
So for anyone, I always forget that, in case anyone's listening and not reading the chat, Critical Mention is the PR/media company, the firm that Fani Willis had hired to monitor media coverage, like involving her name in her office.
Then Meltwater, which is a much more expensive version of the same service, a competitor to Critical Mention. Governor's office again, Lottery Corporation, Road and Tollway Authority, Public Telecommunications, University of Georgia again, several university system units. There's other agencies here. Same. I went back 3 years, 25, 24, 23. Same thing with the General Assembly is an entity, a competitor called Cision that's solicited us multiple times. That you guys have actually spent in the last 2 years $48,971.94 on, which is about double the rate we were paying for Critical Mention in the 2 years we had it early. So media monitoring is an important service for.
All right. So just in case we don't get to the questions, and it's been such a long time, I don't want to rely on my recall. I remember what Critical Mention is, but I don't remember the specifics. But this is why I think it's what the Senate committee might be wanting to probe more into. This article is back from 2024. We initially heard a lot about this from, Ashley Merchant's work. So Fani Willis hired firm to monitor her media coverage value just days before announcing Trump probe. This is why it's critical. So this is why I said I really think it's going to be extremely interesting to watch Jeff DiSantis. I can't believe I missed him. That's why we fired up this live and started from the beginning. I think this is super critical information if we can get to some questioning. So Fulton County District Attorney Fani Willis's office agreed to pay $10,000 on a service to monitor her media coverage just days before announcing the probe into former President Donald Trump, according to invoices and emails obtained by the Daily Caller News Foundation. Willis announced in a letter sent to 4 state officials, including Georgia Governor Brian Kemp on February 11th, 2021, that she had opened a criminal probe into Trump over his alleged attempts to influence the outcome of the presidential election. However, just days earlier, her office contracted with Critical Mention, a New York-based media monitoring service designed for tracking mentions and metrics like publicity value. The documents show Willis' interest in tracking media coverage of herself and her office as she launched an investigation into the former president. The first invoice charging $10,000 for the annual contract is dated February 8th, 2021. Emails show the district attorney's office was in discussion with the company as early as February 1st. So maybe there was earlier, but as far as what was known here, it looks to be like a few days before. So we go monitor our mentions, our name out in media, social media, put a value on it, tell us how we're doing. And we do this right before we do this major newsworthy decision. So, and then we have, we are getting more coverage via your name than by title, Fani Willis versus District Attorney. Said what appears to be a Fulton County employee in a February 2021 email referencing Willis. This graph has the coverage value for the last week at over $150 million. I ran a report for mentions of Fulton County District Attorney worldwide for the last 7 days. Critical Mention, the PR monitoring platform I told you guys about that we contract for the last week, gives a publicity value to the coverage, which is meant to reflect what it would cost to buy paid advertising equivalent to the penetration of the media coverage. So the email continues. While it can be a bit exaggerated, it says in the last week, we've gotten media coverage equivalent to $67 million in advertising. Even half of that value would be staggering. So there we go. I think that's a refresher. It was a refresher for me. I hope it was a refresher for you. It's critical foundation to what Jeff DiSantis is maybe going to talk about here today.
Any government entity that is covered. I would actually argue that it's more important. I wish we still had it. We don't have it. We have not had it. We had it for 2 years-ish. I don't know the exact dates early on. But one, we want to know what the members of the community are seeing about the matters that we are responsible for handling. Obviously, crime being our duty, fighting crime. And, Senator Kauser will know this. I mean, he's a trial lawyer. We get 12 voters in a box multiple times a month to determine whether they're going to send people we think ought to go to prison, and we want to know what they're reading when they come in there. We want to make sure that folks who are reporting on us are accurate. And some of my friends in the Fourth Estate here will tell you that I'm not bashful about calling them up and telling them what they wrote is not accurate. That's my job, part of my job. So it's become this focus, but I'm honestly kind of baffled by it, particularly since it's a widespread normal function for government. Plus, it's obvious what the benefits are of it to the public for a district attorney's office in the biggest state, or in the biggest county in the state, to know what's going on in public consumption.
Senator Kauser, do you object to being referred to as a trial lawyer?
Defense, insurance defense trial lawyer. Insurance defense trial lawyer.
He's going to take that as an insult.
Those litigators were dangerous for all crocodiles. I have the list that's been referred to, and I've marked it as Exhibit 1, and I'd like it included in it.
Yeah, we'll be happy to do that. And I'm not familiar with the portal that you use. I've never personally used it. Does that give you local offices as well?
It does just some, state? And I included everything that was in there, and for some reason, boards of education.
Hey, Baker Raid. Let's give a warm welcome to Broken Baker's channel. I'm going to drop his link in the chat. Good to see you guys. We're not too far. It might look like we're pretty far into it, but we're not. We just started with the Georgia Senate Special Committee on Investigations. Today, Jeff DiSantis, who I'm just going to refer to him as the media and PR guy that's helping monitor Fani Willis and her office's performance. We just got to the part of his testimony where it's beyond his background information, and they're going to get into some meat and potatoes. He's got Roy Barnes here representing him. He's very entertaining to watch, I'll say. And after this, we're going to be able to skip this long break that they take, and we're going to watch Nathan Wade testify. So good to see you guys. Happy Friday. Hope everybody's doing well. And thank you so much, Baker, for the raid.
Are in there, and that's included, but it includes state agencies and a dot in one's agencies, which would include the General Assembly, the governor.
Did you all show up in there? In other words, does it get down to the DA level?
No, it actually doesn't have us in there. I don't know why. I don't know what the reasons are. Although there is an equivalent Fulton County portal that you could look in, and I didn't have time last night to go through and look through every county to see if other DA's office or county governments have it. I presume they do. But it's Georgia Open Government. I actually Googled Georgia Open Checkbook to get it because that's what Fulton calls it, and it came up as a link. And there's a couple different categories. One is agencies and authorities. One is units of the university system, and then there's three other categories. I don't recall exactly what they are, but I'd be happy to provide you with the link if you'd like to take a look at it.
Yeah, I'd be curious to know how many other DA's offices. I would guess that the school boards are captured in there because we do fund those directly from the state as well. County commissions may not be for the opposite
county
reason.
Commissions are not.
So
school boards are.
Just we've seen some screenshots of the portal. I'll put some of these up on the screen in a second. But essentially, it seems to be DA Willis is mentioned, Fulton County Crime is mentioned. You can set up search parameters, and then every time that's mentioned, either verbally or in the written word in the media, then you get a report. You're able to monitor that and track that. You're able to see, like you mentioned, if they're the carjacking that you mentioned that the previous person had, that would be something you could kind of track. Okay. And you set that up just to kind of make sure we're tracking with our timeline here. You negotiated a good deal. It sounds like you got a better deal than the General Assembly. You got it down to $10,000 for that first year. And you were doing this essentially when y'all came into office. This is February 4th, 2021. It's about a month after y'all are sworn in. When did you become aware? Well, I won't ask that question yet. I'll come back to that in a second. You did mention that y'all have not used it in the last couple of years.
My belief is, and this is a recollection, I mean, you're talking about something that's half a decade old at this point or more.
But you're not using it currently.
Well, wait a minute now. Let me finish the question. Finish the answer here.
I'll try to narrow the scope and make it easier for him, but we'll.
Yeah.
But you've got the right answer.
My recollection is that there were 2 annual $10,000 contracts, and they were essentially the first one started someplace in early 21.
Yeah,
and the second one was sometime after that concluded.
Yeah, we have that. We discussed some of that in the last meeting, so I'm just kind of refresh some slides here. So you described this important. Y'all are in year 5 of the term. You haven't used it for the last 3 years. What are you using for media monitoring now?
We've been doing it manually. I really wish we had it, and I know this. I'm not trying to be provocative, but honestly, like every DA's office and solicitor's office ought to have it. PAC could probably get a contract with some equivalent thereof. you ought to know what your jurors are reading. You ought to know what your citizens are concerned about, what they're hearing about crime, or whatever categories of crime a DA, solicitor, whoever might be concerned about. I presume that's why the Attorney General's office has TVIs, which is a competitor to critical mention. It's a we haven't had it. I wish we had it. We actually have looked around. My recollection, and again, you're talking about many, 4 years ago, probably at this point, maybe a little less. I was slightly annoyed when I figured out that we were paying a little more for critical mention, even though I negotiated it down, and they did a couple counter proposals. I kind of let it go. We've actually been looking at some other possibilities like TVIs and Cision that you all use, but we just haven't engaged it yet. I've been doing it other ways.
You were annoyed at $10,000, or there was an attempt by them to raise the price?
I was annoyed that I found out we were paying more than some other folks, and I let them know, and they came back with some lesser number, but I was annoyed, and I sort of let it go. I was annoyed for other reasons, because there were things about it that annoyed me. No reason to bore you with it, but I was going to change anyway.
So was it your decision then to cancel that contract, and you just haven't renewed?
It was my decision not to seek renewal of it with the process.
Okay. This is an email that we did bring up before that you sent to Ms. Willis on February 17th, which is 12 days after that contract was signed, and was 7 days after the record retention notice was sent to Governor Kemp and Secretary of State Raffensperger. And that record retention notice was in relation to what was probably called the Trump election interference case that would go on to become
that would make sense. I don't have specific recollections of what the contents of said communication was, but yeah.
Yeah. So you sent this PDF that it essentially, looking back over a period of time, shows a spike. But this is what I want to understand a little bit more of, because when we were just talking about this, you referenced understanding kind of the public's perception of certain crime cases, what the jury may be seeing. But there was a pattern over that first year of tracking earned media value, and earned media value would be kind of the free news coverage that any of us receive for, when our name is mentioned, and these services attempt to put a dollar value on that. And this was the first email that we saw, I believe, relative to critical mention. And I'll read this here. The analytic graph is attached as a PDF. The previous one I sent was for, quote, Fulton County District Attorney. This one is for, quote, Fani Willis. We're getting more coverage via your name than by title. This graph has the coverage value for the last week at over $150 million. That's obviously high, but even adjusting downward, still a huge number. I'm curious help me understand why you sent that email.
Again, it's over half a decade now. I will tell you, it was not solicited by her, nor was I instructed to do it. I think I was just be like, hey, a lot of attention. She was not particularly interested in it, I'll be blunt. She probably turns down 90% of the interview requests we get, as some of our friends in the room here will tell you. I don't recall exactly why, but I think it was just more like, hey, look at this. And it was me, not her. And it was, there's no cost to running a search, so I just ran it. I'm like, wow, this is a lot.
Yeah, this is.
And we were surprised. I was surprised. I don't know. She may not have been surprised, because I don't think she really cared.
What surprised you?
That many people had reacted to that particular relatively common move to say, hey, in litigation, hold on to your records. We might need them.
Gotcha. The record retention notice.
Yeah.
That she had sent. Okay.
That's the only thing I can recall that was in there. There was also other stories. I will say that she was a topic of great press interest in the campaign for whatever reason. I've done a lot of campaigns, and I was surprised at the amount of press interest there was in that. Maybe it was because of COVID, or because they think she's good TV, but she gets covered a lot, even though she doesn't do a lot of interviews.
Was that the case before the record retention as well?
Absolutely.
So first month or so in office. Obviously new DA.
New DA.
Y'all are speaking over each other.
Okay, you're right.
Okay, go ahead.
Sorry.
Go ahead. You need to do the answer now.
Okay. Thank you. Honestly, and having been around law and politics, I was surprised from the get-go about how much coverage that campaign got. In fact, I joked to her that I should have charged her a lot more money, so how work it was.
Okay. This is a PowerPoint presentation that you gave to the executive team at the end of that same year. Obviously, coverage had grown. This is a title of the slide: media during the term. I think you mean using the term, perhaps, but during the term Fani Willis, January
Yeah,
1 through
correct.
November 30th, 2021. Same search term that had yielded $150 million in that first week. And here we're at $637 million. This was part of a broader PowerPoint presentation that you put together, essentially saying, here's what my office has been working on. Did you view it as part of your role to build the name ID of the district attorney?
Now, are we gonna spend, we're spending more than $10,000 just talking about $10,000.
What's your rate, Governor?
Talking about with y'all.
My rate's pretty low, I can promise you that.
Well, no, you're paying all of these people, paying a court reporter, you're paying 5 staff members about $10,000. And I thought we were here to talk about, as the resolution said, hiring of special assistant attorney generals, or district attorneys, I'm sorry. So,
Does council have an objection there? Because I think we've spent a tenth of an hour talking about this.
resolution.
That the question is beyond the scope of the resolution as to the impartiality and the perceived conflict and the political motivations that are stated in the resolution?
Well, it's a little difficult to tell from what the matter of the investigation is, because whereases, as you well know, generally have no effect whatsoever either in a contract or in the law.
Except where the recitals are then utilized to inform the exact
Correct.
purpose,
That's
as
correct.
specifically
And
stated in the
there is
resolution.
But what it says is that you're dealing with the hiring of a special assistant district attorney. And this $10,000 expenditure 4 years ago apparently didn't get a good a deal, the state didn't get as good a deal. Why is that relevant to this inquiry?
As council has mentioned, one of many bases that are listed in the resolution and stated as part of the purpose and subject of the investigation. Mr. DeSantis, I would advise you that I think you can get a lower hourly rate now if we spend $10,000 discussing this. But Mr. Chairman, you can move forward with the
Oh, I'm not
questions.
talking about my rate. I'm talking about what you're spending. 1, 2, 3.
All right, we'll get back to that question and hopefully cut down on the expense here, Governor.
Okay.
So the question was, I think, I don't even exactly recall, but what's the purpose of gathering this information?
Am I answering that? I'll take my advice of counsel on this.
Internal process, and it's been asked and answered, and I object to it. I'm going to instruct him not to answer. Move on. I mean, we're going to be here all day arguing about, well, why did you do this and why did you do that?
Well, let's get to a potential motive here then.
Well, there's not motive in here now. There's not a motive here. I mean, this is not.
Well, we'll get the bias that he mentioned, this part of that whereas. If you want to read that again, Counselor.
The bias.
Well, let's let him read that
Let me
section
just
again.
walk through a couple different items here that come into play. The various forms of misconduct in line 6, the expenditure of significant public funds in lines 8 through 9, in line 15, the
But that
appearance
goes to
of
the
appearance of
prosecutor.
impropriety that infects the current structure of the prosecution team, in lines 27 through 28. The undermining of public confidence in the fair, impartial, and disinterested administration of justice by prosecutors across our state. And then it goes on, that's just a handful of items that we'll list here. Go and skip ahead to 40 and 41, the selecting, hiring, and compensating of special assistant DAs. Line 57 as to the expenditure of public funds by district attorneys, and then brought all together in the enacting, substantive enactment of the resolution of the committee's authorization to undertake a legislative investigation into the issues mentioned above or related thereto. Respectfully, counsel, I think the question at least relates thereto to the purposes that we've just described. If counsel is instructing the witness not to answer, then we'll have to take that up in a different forum potentially.
And that's fine. Well, and we'd be entitled to a jury trial. I'd be able to subpoena all y'all. And we tried that in Fulton County, and we can do that. I'd like to have several of you on cross-examination by a court. Now, but there's no expenditure of state funds. The state funds pay for, you're not a state paid.
I am not, I'm county.
He is a county-paid employee, so it has nothing to do with the expenditure of state funds.
Of course, Governor, you are well aware that money is a fungible item.
Well-
Setting that aside, I believe we've established that as far as the objection as to relevance has already been, I understand that to be council's objection. Mr. Chairman, by review of the resolution indicates that this is relevant and fairly related to the purposes of the committee. I believe you're entitled to continue to pose the question in the line of
All
questioning.
right, ask the question again.
Okay.
Now, I forgot.
We'll get back to this. The $637 million that's on this slide here that you presented to the, or at least was, I guess you put it together. It's the Media Relations Executive Team Presentation 1. What is the value as it relates to your original testimony in terms of tracking public opinion of cases, public opinion of crime? How does the earned media value for the term Fani Willis support the original contracting of critical mention that you just testified to?
You can answer that. Let's go ahead. Let's
Okay.
see what you say.
Well, first of all, I'll say I was not instructed to put that together by anybody, district attorney or anybody else. I did it. There was if I recall, and I will point you to the
I did it and I chose this nice bubble-themed PowerPoint template.
date. You're talking almost, you're over half a decade ago at this point. But my recollection is every unit leadership meeting put together a presentation about what you've been doing, what you're going to, do going forward. I haven't reviewed the PowerPoint in many, many years, but I recall that. I think I did it as hey, we got a lot of incoming. It was part of it. The other was informing the district attorney and the staff of the platform they have. And one thing that I say, we always have a conversation with folks. They're not allowed to talk to the press without going through the proper channels, but we also want to know about things they are working on that the public needs to know about, because in an office that large, and I remember this from the Attorney General's office, I was constantly fighting to be like, hey, this is a consumer protection matter, for example, in the AG's office, or this is a gang matter in the DA's office. Let's make sure the public knows about it. I mean, for example, our anti-gang initiative that she has taken a very hard stance on, rightfully so, and there was a gang problem when she took office. It is significantly improved. There were people in the business community and the government who didn't want to either didn't believe it, thought it was bad for business from a Chamber of Commerce standpoint, frankly didn't want people talking about it. We made a concerted effort to not only prosecute gangs, but to tell the world, including gang members, that we were prosecuting them, and that Fulton County, the city of Atlanta, was no longer the place to come to do gang activity without consequence. And I would point you to the crime numbers in the city of Atlanta to say that it has worked, and we've had a great relationship with Mayor Dickens in the Atlanta Police Department on that topic. So that's the platform that the office has is important, and that was my recollection of the conversation in the meeting. But again, it's over half a decade old.
Okay. When this payment was made, do you submit the check request for it? Do you recall?
I know I did it first, and I think I probably did both times. When I first got there, we were one of the only offices in downtown Atlanta, certainly in Fulton County, that were in person, because she insisted on people being there in person because we were in such a hole that we inherited in 2021. And I remember doing it then. I can't remember the second time.
The one thing that we saw that I just wonder if you have any information on, we asked this to Ms. Willis, and she did not have really specific information on this. There was 2 separate accounts this was paid for. The first kind of through the normal payment voucher process at Fulton County through the general fund, which is really the bulk of what we've seen in this case as we've reviewed the financial documents. And then the only place that we've seen this checking account appear in the records that we have access to so far is from this checking account. Did you do anything different in the check request process that you recall that would have caused these 2 things to be paid out of 2 separate fund sources?
No, I don't. And fund sourcing is not my area of responsibility or expertise, so I really don't have any.
Are you all familiar with this checking account, Fani Willis, DA, Fulton County?
No, not in any. I mean, I see your name up there and see the check, but beyond that, I don't. That's not my zone. I don't know what the setup of the office is.
Okay. Almost wrapped up here. I do want to ask you about Charlie Bailey. Was obviously a part of this case. There was an investigation into then Senator Burt Jones, candidate for lieutenant governor, obviously go on to become our lieutenant governor. And there was a disqualification from your office, or the office, I'll say, investigating Mr. Jones due to this fundraiser that happened for Mr. Bailey. Do you recall kind of
I recall the occurrence, yes.
And I think maybe showed some of this before, but you've had at least a previous role with Mr. Bailey's political campaigns. This here.
Well, y'all talking on each other.
I'm sorry. I'm trying to,
Yeah, well,
I heard this was an Italian thing. You sort of encourage people to keep talking.
this here is an article of the Corporations Division, Secretary of State. You're listed here as the registered agent for Charlie Bailey for Georgia, Inc. In 2018. Last registration year of 2022. And I want to see what that bottom says. I can't see it on the screen there. So you're the registered agent and the secretary, and then Mr. Bailey is the CEO and the CFO. That's what the bottom of the screen. You might be able to see this one easier to your right.
I see it, yeah. I'm familiar with those corporate records.
Yeah, just give us background on what this is, what your role was with Mr. Bailey when it ended, if you were involved in his run for lieutenant governor, which is in question here when he was running against Mr. Jones.
Well, in 2018, I've known Charlie Bailey since, mid-2000s. We'd been friends and worked together in different contexts. He decided to run for Attorney General. We had talked about it. I set up the campaign in 2018, which would be part of what I would do for my clients. That's a previous address of mine, including the P.O. box. So that's when I would have put that down. I do not know, honestly, when that might have been changed. I think I would have probably had a conversation of, hey, you need to go ahead and change that. He knew I was going to work in the DA's office. But I don't recall exactly what the corporate record transaction, but I think as Governor Barnes may have pointed out, that was a 2018 creation. I think he probably kept using the same corporation for because originally he was running for Attorney General again in 2018 or 2022, and then he decided to run for Lieutenant Governor at some point relatively late in the process.
Okay. You served as GC on that campaign, the 2018 AG
In 2018,
campaign?
I was a consultant for him, yes.
Did you have any role in the 2022 campaign?
No formal role. He's a friend of mine. We talked, but I had no formal role in that campaign. I was a full-time employee of the DA's office.
Did you have any conversations with DA Willis about the fundraiser for Mr. Bailey?
Not that I can recall. Certainly we did once it became an issue, and the press was asking about it, but I don't recall any conversations about, you got to go do a fundraiser.
Did you have any conversations with Mr. Bailey about that fundraiser that you can recall?
After it became an issue, I believe we did, and I sort of found out what the circumstances of my recollection is. His campaign had posted something about the DA. I would point out, if you look at the precedent in that, and I think the DA alluded to this in her testimony, if you look at the precedent, for better or worse, our DAs are elected. What they do as candidates is generally considered to be separate and apart, unless you're running against somebody, from what they do as prosecutors. I think she pointed out that the judge in that case didn't hold himself to his own standards, since there were co-conspirators, fake electors, who did a fundraiser for him, including when that whole matter had come to light in the press. So judges are at a much higher standard than prosecutors as a general rule. But that said, I created his campaign in 2018. He's a good friend of mine. Still talk to him as a friend. There's not really not much more to it than that.
Okay. Do you still work with 2020 Insight?
No.
Do you still own 2020 Insight?
I don't consider it to be my company. It's not a going concern in the sense that it has any assets beyond its bank account. That's run by somebody else who uses it. I used it prior to my role as a district attorney, as deputy district attorney, as a side project.
You said that's run by somebody else. Is that Mr. Hutman?
It is.
Okay. And so here this is, I think, currently on the website, and this could be dated, but this essentially was 2020 Insights created by you, by Mr. Hutman, or both of you?
I incorporated it since I'm a lawyer, and he was doing things sort of informally for people, primarily polling, and I said, hey, we should go ahead and incorporate, and we both use it in the past. I don't do it now. He still does work through it, I believe. You could look it up on a campaign finance disclosure if you want to see who his clients are.
We did do that, and so did see some clients such as Ms. Willis. And it looks like Mr. Hutman also works with Canal Partners Media.
He does. Just to be clear, 2020 Insight was never a full-time endeavor for either of us. I was practicing law and doing other consulting, and he has worked at Canal Partners or its predecessor company for years.
And you've not worked with Canal?
I have never been an employee or an owner of Canal.
Okay. So any campaigns any campaign work you've done under 2020 or some other entity, not Canal?
Correct. I've never been I am certain that I have run campaigns that have used Canal Partners Media as a consultant, to be clear, but I would refer you again to campaign finance disclosure. That is one of the largest political time buying firms in America. It happens to be based in Cobb County, but it's not a niche company.
It looks like they've done hundreds of millions of dollars of work for presidential level campaigns on the Democrat side.
They do nationwide work.
Yeah.
They're one of the major time buying firms in the country.
Just a couple more questions, and then Leader Jones, just give you a heads up. We'll give you time, as we always have as well. And then I'm almost done here. I do want to ask you some questions as it relates to the actual Trump election interference case. and conversations that you may have had with people either inside the office or outside the office. I'm just going to give you some individuals. I'd like to know if you've been in conversations. Did you have any conversations with anyone at the White House relative to the Trump election interference case?
Now, are you just saying, well, when you say, did you have any conversations with anybody at the White House concerning the Trump?
Yeah.
You're getting into the content thereof.
I think that's the same thing that we've already covered in a previous objection.
I don't think so. I think that you're talking about
Let's-
concern.
I don't mean to cut you off, counsel, but if we can state the substance of the objection here.
The substance of the objection is anything regarding a content or a practice or procedure of the Office of District Attorney is
As a deliberative process, is that,
deliberative
am I understanding that correct? Is it that your position, Mr. DeSantis or counsel, that the White House has a role in the deliberative process of a state
well, it could be
district
more than
attorney?
a deliberative process. It can also be, could be as a part of practice or procedure in obtaining a witness. And obtaining a witness would be a disclosure of the deliberative process. I tell you what, go ahead and answer.
No.
Okay.
And I would not have. I don't really recall even knowing anybody I would call there, but I would not have. I would not have ever done that.
Do you have any role in the Office of Obtaining Witnesses?
My role actually was informing the public because we had to use a special purpose grand jury because unfortunately there were witnesses who wanted subpoenas rather than to appear voluntarily, including government officials, and that's their right. I mean, they don't have to appear for anything. If they were out of state, we had to go through the interstate compact process, which was public, unlike a federal process, which can be nationwide and private. You got to file in court. I mean, it's not really the same, but it's sort of the equivalent of domesticating a subpoena in a civil matter and get a local court to compel them. That's all filed publicly and there are public hearings. So I would provide to the press, the public's representatives, these have been filed once they were actually filed into the public docket.
But as far as working with anybody to get people to testify or find you
No,
witnesses,
I
name
didn't.
you
I
witnesses,
did
that's not your role as a
No,
media guy.
I'm not trying to waive any privileges here. So
Why is that not what he does? I'm going to object. On the purposes of what he may or may not do in a particular case is a part of a privileged situation.
Okay, well, given that you answered the D.C. question, let's get through the rest of these, and maybe you're willing to answer all of those as well. Have you ever met Alvin Bragg?
no,
Have you ever met Jack Smith?
no,
Have you ever met Michael Colangelo?
Michael, who?
Colangelo.
Who is he?
He was the gentleman that left the Department of Justice and went and worked for Mr. Bragg. That was one of the leads on Bragg's prosecution.
no, we've never met.
I thought we were talking about Ninja Turtles.
They convicted the president of 34 counts.
Counsel, we don't have you sworn in as a witness.
Well, I'm just wondering. I'm just trying to find out who
He said, let's look at the panel. He said, let's just swear Roy Barnes in, doing all this opining.
people
I like his hat.
Mr. Chairman.
Did you ever talk to any of Mr. Bragg's staff about the Trump election interference case?
No, I don't believe I did. One thing where we had
I'll mute you. You're muted.
Yeah. Yeah. Okay. I will,
Sorry, you're back on now.
I don't believe I talked to anybody in his office. I think I talked to somebody in our office. But I recall Mr. Bragg's office essentially wanting credit for helping us compel Giuliani to show up through the interstate compact because he didn't want to come, and there was a whole hoo-ha about it where, the judge was like, Giuliani was like, I can't fly, I can't come down, I'm dying. And then we produced pictures of him partying with women, and the judge is like, maybe he can take a camper if he can't get on a plane.
Sounds like Tyrone Blackburn.
And I remember, and you could probably find the quote, which I'm sure you probably have, of me saying something like, we really appreciate Alvin Bragg's help. And the reason I was asked to do that was there were other witnesses in New York County, Manhattan, that they thought they might have to compel. And they wanted to make sure, because what happens is we file here, it goes up there, and then the local district attorney does it. We do the same thing if there's a guy in Atlanta that they want in New York. We go to court and compel that person to show up. And they wanted to maintain good relations. So I think I went in the press and said, we really appreciate Alvin Bragg's help in compelling it. I believe it was Giuliani. I'm 90% sure. If I'm wrong, again, it's several years ago.
I don't have the quote, but I'll go look for it because it sounds
But
spicy.
that's when you go find it, that's where that came from.
Got it.
And it was at the request of Bragg, who wanted credit for
I do want
doing
to.
his job, cooperating.
I want to extend my previous questions where I said, did you talk to? I want to make sure that we're including all forms of communication, not just verbal communication.
I don't believe I did.
Okay, so
I
that
don't.
would-
I recall talking to somebody in the office about, will you say something nice about Alvin Bragg helping us? But is there
In which office?
our office?
Okay.
As it
In
relates-
our office. It was somebody in our office saying, hey, we might need them to help us again. They want us to do this. Will you make a public comment saying they were helpful, which is their job, but they wanted that, so I agreed to say we appreciate Alvin Bragg's help in, going through the process to compel this witness.
I want to extend the same question in terms of I asked you talk to. I want to make sure I include any sort of written communication as well. With the White House, is that a no as well? And
Yeah, no, I did not communicate with people in the White House. I don't recall communicating with anybody in the White House.
Jack Smith's staff, same
No.
thing. The Department of Justice.
We have contact with the Department of Justice on a regular basis in Atlanta, primarily about cases. There were circumstances where the U.S. attorney, whoever that might have been at the time, and the DA did meetings about, or public press events about cases, something called Credible Messenger, which gets people that have been in trouble to talk to on-the-edge youth over the summer about not going down the path they went down. So I had interactions with, a fellow over there who was in press. And I recall another time that a group of us talked to them about taking more gun cases. Since
But as it
we have
relates
a
to
lot
the
of-
Trump case as well.
No,
That's
no.
specific. Okay.
I mean, no,
The Jan 6 committee,
no.
relative to the Trump case, no written communication?
Now, let's make sure that the question, whether he had any.
Correct. Yep.
Yeah, no, I did not have conversations with the January 6th committee or staff about that.
Mark Elias?
No.
Who is Mark Elias? Maybe I'm stupid about that.
I think he's a political operative, lawyer.
He's a lawyer.
He's a guy that's kind of been out there pontificating, I believe, on kind of the structure of these cases and how these cases should be prosecuted. Norm Eisen?
No.
Okay.
I mean, on Elias, you're limiting it to my time in district attorney's office.
Yes.
He was my lawyer one time in a campaign I was running. I mean, he's actually a competitor of mine when I was doing campaign finance stuff.
You run your campaign, Governor?
No.
Is that the one?
I was.
No, he's been against me.
I've
That's what I was saying. I'm saying this other guy.
So,
All right, so I want to turn the question over to Leader Jones. I want to clarify
It's a small world. Small world.
just that everything that I was just asking about was specific to the Trump election interference case. I don't want
Okay,
you to,
yes,
to
no, I did
feel
not
like you gotta
communicate with
go
any
back
of those
in time.
entities about the Trump election interference case.
You on there, Leader Jones? Oh, they got you on. You're good. They got you on. Okay.
Thank you. Just thank you for coming in and showing that these non-issues are truly non-issues, and that's all I have for you. Thank you for coming in. Thank you.
Happy to do so. Thank you.
All right. I'm going to take a quick 5-minute bio, and we'll come back and wrap up questioning in just a few minutes. So you can
Bio's their
fine.
comfort break.
Yes, sir. That's correct.
Okay.
Just give us a couple minutes. We're almost done.
All right. And then it looks like they don't actually come back in 5. So we'll jump whatever. We'll make sure they actually leave. See, what I think is kind of paradoxical, in just an interesting way, food for thought, is the idea that this is an investigation into not really just the decisions of Fani Willis's office in and of themselves, but did the decisions that she and her office make, is there misconduct and misuse of taxpayer funds in relation to anything surrounding the context of the Trump 2020 election case? And it's interesting because misuse of funds, well, on one hand, you might be saving a lot of money by getting publicity you might otherwise campaign to garner up. And you need to raise funds or come up with some type of funding to fund that campaign, to get that publicity and get out in the media and get that coverage. But in a way, you're kind of replacing and offsetting that by it just kind of going organically viral. Now, if that's for better or for worse, who knows? There's the philosophy that there's no such thing as bad press. And then on the other hand, is it complicated? Is it complicated beyond just, hey, we're not needing to spend money on this campaigning because it's just going viral on its own? There's this layer here where the timing is just a few days before we announce this prosecution that we plan to open up this investigation. We're looking to prosecute. We want heads on platters or whatever. We hire and contract this media monitoring firm, right? So it's layered here. It's layered here. And speaking of money, speaking of campaign contributions, just kidding, we have generous support here for the channel and the chat turning green with 5 gifted subs from Sheriff Chuck. Good to see you, Sheriff Chuck. You just missed some fun times with Roy Barnes. He's going to be back for a little bit, but I think you've missed some fun banter. Good to see you. Hope you're doing well. The chat's already saying thank you. Santa Chuck. There we go. And yeah, we're going to skip this break, you guys. I think I'm queued up pretty close. And if you're watching on Replay Crew, I've also added, I talked about 2 different links. One with a little story on critical mention, and then, well, it's 2 links for the Diversion Center program that isn't really all that efficient, and it could be operating to divert more arrests, and it's not quite getting there. So those are in the description for you guys on Replay Crew.
We took a trip to New York City.
Ooh.
One thing, when I went to the facility,
Oh, okay. I thought it started in the middle, but it sounds like he's just coming back and giving banter. Let's just want to make sure we didn't miss anything.
one thing, when I went to the facility, I was thinking about, we took a trip to New York City. We met with the outer boroughs. I don't believe I remember interacting with Bragg's office. Well, not Bragg. And we went up there to look at programs that they do. If you may recall, I don't know if either you or Senator Kauser or Senator Jones were on the committee about the jail and Fulton County processes, but Kenneth Hutcherson, who's the head of our case intake division, testified as to how much smoother and quick New York City's process for getting evidence from the police department to us, to the prosecutor is. That what came out of that thing. I don't believe that I talked to Bragg's office then. Is it? I don't recall, but it's possible in that context would have had absolutely nothing to do with any case in Bragg's office, much less the Trump case. But I just want to make that clear that
Sure.
it's possible that there was some interaction about.
Do you remember when that
Clearing
was,
it up.
ballpark year?
20, I don't even know. Maybe 2024, 2023, probably 2024. I don't know.
Okay, so well after this was kind of rolling.
Yeah, but it was about, we went to all the boroughs, although we did not go to Manhattan, but we went to the various boroughs to look at how they did it, and frankly found both with the crime lab, you know, they turn stuff around very quickly, and I know the DA brought up, I mean, that would be a great thing to fund. We've been told by GBI to go get our own ballistics tests at times, which is very expensive because they can't turn them around in time, and obviously we're a major contributor to their ballistics duties, workload, as well as she has mentioned it. I don't know if it's a current policy, but at one point we got a memo or some kind of communication saying that they would only test one drug if multiple were seized from a drug house or a drug dealer. So you could have somebody with fentanyl and heroin, and they'd only test the heroin, so we can't charge them with fentanyl because we don't have the evidence, or it'll take so long that, you know.
I mean, that sounds like the right way to do that, but for those, like, my personal awareness of Fulton County prosecution, sometimes it seems like these charges move forward anyway. And here he's like, well, we can't charge that because we don't have the evidence. Is that always how it goes? Or when do we decide, is it more correct to say we might charge it even if we end up having to null pros or drop it or do something with it later?
Multiple were seized from a drug house or a drug dealer, so you could have somebody with fentanyl and heroin, and they'd only test the heroin, so we can't charge them with fentanyl because we don't have the evidence, or it'll take so long that you end up having chain of custody claims, and it undercuts the prosecution because we're sitting there waiting on the drugs for so long. So that would be a great thing to use some of the remaining of your 40 days to fix if you are so inclined.
That's good feedback. Thank you, Ashley. I think I mentioned this earlier. We're in the appropriations process now, and those are all relevant things to take into consideration.
But I recall there was testimony about that New York trip to that committee, specifically about those issues. And particularly, I recall there was a case, I think it was in Queens, but I'm not positive, where a drunk driver ran into a school bus, and they had every piece of evidence they need and indicted the person within 72 hours because the dash cam of an NYPD cruiser plus the lab results for the intoxication were all back instantly, and it just moved right through the process. So,
yeah. I think I've covered everything I've got here. Any other members of the committee? Senator Jackson, you're not officially a member of the subcommittee, but if they would be agreeable and you want to ask questions, would be Chairman Kauser.
Ask a couple of them.
Yeah, well, you're recognized.
That's my impression,
Thank you very
Coco.
much, Mr. DiSantis. You made a comment earlier on that you were surprised that we were surprised by the critical mention use. I think part of my interest in that was we had seen your slide where you were presenting the earned media value and your sort of email reports to DA Willis, letting her know how many people have been reading about her and how much value it was and whatever. So I didn't understand the total purpose of that critical mention.
Understood. And I know it's been raised by opponents of the prosecution is some kind of issue, but I've been surprised at this sort of seizure on that topic.
I think that's why, because we took it in the context that you were reporting on the value of the critical mention, what it had shown you, the mentions. Wind me back again. What is your exact title or your position within the DA's office?
I believe she calls it media and strategy.
So you don't actually prosecute cases yourself, even though you're an attorney.
I have not entered an appearance in a case. I have helped on cases in various forms, including writing, editing. I'm not going to get into any particular case. Obviously, whether I've entered an appearance is a matter of public record. But it's I got a variety of things that I do, but
Mostly
is
a
one.
media relations spokesperson type role.
That's a major part of it. I don't know exactly if you divvied up the time, what it would come out to be, but that's a major part of my job.
Haven't entered an appearance as a prosecuting attorney in any case in the
Correct.
outside. Did you have any role in the election interference case? I don't remember if it's 18 or 19 indictments, other than coordinating the subpoena issuance with the out-of-state DAs?
Well, just to be clear, I didn't coordinate.
All right.
The persons assigned to that, whether they be prosecutors or investigators. Am I getting into stuff I'm not supposed to get into?
Well, state the question one more time.
You didn't have any role in the election interference cases other than putting somebody in contact with the out-of-state DA to issue a subpoena?
Well, to be clear, I didn't put anybody in contact with an out-of-state DA. I don't want to waive any privileges here, but I'm trying to abide by my duties in the office as well as in a lawyer. So
I'm not trying to invade that
Yeah.
privilege. I'm sort of setting the foundation, because the way you've described your role is that you weren't a participant in this prosecution. You weren't advising, you weren't making decisions, you certainly weren't counsel of record.
I'm sorry.
So if you had some role, tell me, because you might have a privilege. If you're the one that said, D.A. Willis, I think you ought to prosecute Burt Jones or President Trump.
Well,
Is there an objection to that?
yes, there is
What
an
his role?
objection to that because it gets into the content
Okay.
of what might or might not have been said. And let's be clear, two grand juries are the ones that recommended and indicted anybody.
And they recommended a whole heck of a lot more than actually got prosecuted. And I'm
Correct.
trying to find out if he had any role in that or not. If he
that
didn't,
would-
then there's no privilege. If he did, then I'll cease the question.
Well, but whether he did or not, what he recommended would be a part of the deliberative process.
Right, and that's why if he made no recommendations or had no role, it is no involvement in the deliberative process. And I don't think the privilege would apply. If he did, then just tell me he did, and then we'll realize what his scope of his practice was.
You're muted.
Okay, we're going to answer it thusly.
You're unmuted.
Go ahead.
well,
You're unmuted. Or sorry, you're muted.
I won't let you get into that. Yeah, all right.
on any case, I don't think I'm permitted by both the office and its privileges and my duties as a lawyer to say I was in this meeting or that meeting regarding what was discussed. I can say I did not recommend, charging decisions on any case. Well, no, that's not true. Let me back up. The leadership is required because of the backlog to help go through backlog cases, not the election interference cases, obviously not in that category, but everything from
Yeah, they
guy
got
broke a
pretty-
window at the motel to somebody, committed domestic violence to worse, armed robbery. And there was such a stack that we all spent a lot of time going through, and ultimately it'd be reviewed, but you'd say, I think this one's a bum case, let it go, or this one's under charge, or this is a misdemeanor, send it to the solicitor, whatever. But I was not a recommender of charging decisions in those kind of cases.
Is that backlog you're referring to what D.A. Willis came in here and said she's got 2,000 cases or something that she's trying to work her way through? She was asking for more resources.
Yeah.
Yeah, I mean, there were something like 18,000 unindicted cases when we got there, some of which dated back to like 2009. So some of it was a pandemic, a lot of it wasn't. And some of them, we were like, the statute's gone on this thing. Obviously murder, not, or some sex crimes, not. But, there were over 100 cases involving police use of force that had just been sort of sitting there that we made a commitment to get through within, I think, the first couple of years, which I can't remember the exact time frame we promised to make a charging decision one way or the other, and we did. There was also something like 60,000 cases that were not properly entered disposition-wise into the system, which then doesn't go to GCIC or NCIC. So, for example, you have somebody who committed child molestation, doesn't get into the system. They move to Minnesota and apply to work at an elementary school. They run a background check. Their Fulton County conviction's not going to be in there. That had to be fixed as well.
So is that, when you mentioned the disaster that you inherited, is that what you're referencing, the backlog of cases, improperly processed cases in the past?
That would be a major part of it, absolutely.
When you say,
Either not properly closed or just sitting there, undealt with.
unindicted or undismissed or unresolved?
Unindicted, undeclined, unsent to the solicitor, whatever the unsent to diversion, whatever the circumstance may be.
So you said the senior staff would look at that. Was that like a team of senior officials that you were part of that kind of helped work through this backlog?
Yes, nobody has one job there, and we were up to our eyeballs in inherited problems.
How has that caseload been resolved, or what progress has been made? If it were 20,000 sitting there, half of them are stale or not timely or not resolved?
I will say the inherited backlog has been gone, and the number of pending cases is way down. I should have probably reviewed that and brought it. I don't want to start speaking numbers. She could tell you off the top of her head because she rides everybody in that process to get them dealt with, but I don't.
That's interesting because I feel like when Fani Willis, the last hearing we watched with this committee was Fani Willis's testimony, and I really wanted those numbers, and I felt like we went on and on with this top level verbose back and forth. It was like not controlled, and I wanted to hear those numbers. And now this guy who's done, it's been interesting to see some numbers presented, but in relation to like critical mention and the media, the stuff that's more his actual function, his role. He's talking about the numbers of cases on the backlog and that they inherited, that they've cleaned up and that they're doing well. The numbers are going down. And I'm like, cool, we're about to get some numbers. And he's like, but she would know those numbers better. She's talking about them all the time. But it was disappointing to not get those numbers when Fani Willis was hearing. It actually felt exhausting to watch that hearing and just not get the numbers. It seemed like a critical part of what she should have been testifying to. So we're still not going to get numbers on the case backlog.
Have the number in my head.
Have the resources that were spent on the election integrity cases and the Young Thug case sort of added to the backlog by diverting resources on those missions?
No.
What? What? They're just saying no? That can't be true. Do you get... Maybe I'm disillusioned. Do you think that's true? Let's run that back.
Speaking numbers, she could tell you off the top of her head because she rides everybody in that process to get them dealt with, but I don't have the number in my head.
Have the resources that were spent on the election integrity cases and the Young Thug case sort of added to the backlog by diverting resources on those missions?
No.
In your role as media relations, you mentioned the fourth estate. That's the press, right?
Correct.
Is part of your job to reach out to them
There's
yourself?
no way.
To encourage coverage of certain issues or to shape the coverage or, plant stories, so to speak? Is that part of your role?
Well, some of that, yes. Some of that, no. Planting stories, no.
I don't mean that in a negative way.
Yeah.
I just mean by calling the press and saying, hey, you all need to see, we just had a grand success, or we've got this very interesting crime we're prosecuting.
I would say most of
annoyed.
the pitching, for lack of a better term, would be about non-cases. It would be, she started a pre-indictment diversion program. The REACH program, that's where the office is in originally Fulton County at the request of the superintendent, now at Atlanta schools, and, working with kids. The staff of the office is in there every week. Like I mentioned, with the U.S. Attorney's Office, the Credible Messenger, which is a similar type of program, although I think, unfortunately, that's been abolished by the current DOJ. Sometimes there will be, I do look at the indictments that come out. The office gets a list, everybody gets a list of who's been indicted, and I'll look at the major crimes, and if a reporter wrote, someone who got arrested for shooting somebody, I might say, hey, the next step happened. This person's now been indicted. But yeah, there are times when we know there are reporters interested in particular types of cases or a particular case where we'll say, hey, the trial's starting Monday, or it's in jury deliberations. I mean, this is a normal part of the job to keep people informed, and that's part of how we let the public know again about what we're doing, and including the people that might do wrong, that this is not a place that's going to not try to hold you accountable.
Are you the contact if the press wants to interview Fani Willis? Does that come through you?
Yes, I mean, it would be me, and yes, it would be me. I'd be in that contact. Sometimes they contact her directly, she'll forward it to me.
Yeah. And you let her know, and she gets to sort through and decide which ones to accept.
I let her know, and she says no 90% of the time, and
Yeah.
half the time I say, well, this might be a good one to do.
Well,
But she's not interested.
From my just casual observation, she does not seem to be publicity shy. I mean, we've seen her come in and testify in committees before this one. I mean, not our Judiciary
True.
Committee on prosecutorial oversight. So she must take some initiative on occasions to get her viewpoint out there, right?
Well, I mean, to be clear, I mean, obviously she was here under subpoena on December 17th, but
I'm talking about Judiciary Committee.
Y'all are
Yeah.
talking over each other.
sorry.
Thank you, Your Honor. I think we'll
Sorry.
be okay without your
I wanna make
interference.
sure that if I ever use the
Yeah.
transcript, I can use it.
You'll be able to.
my error. But no, I mean, she, for example, in that particular hearing, which I recall, I think it may have been the first time you and she met. I believe she was asked to speak about that bill by other prosecutors, which she's willing to do. She obviously got an important job and opinions and observations she wants to share with the public. So yes, but as far as sort of a general, how much press we get and get me in the press, get me good stories, I've actually never had that conversation with her about sort of in a generic sense of like, give me more stories, which a lot of elected officials, I'm sure you guys know, will have that conversation with people that work for them. I've never had that with her.
So critical mention was mainly just a reporting agency for you to, it's almost like doing a big old Google search for you and letting you know anytime either the Fulton County DA's office or Fani Willis individually gets mentioned in the press.
Yeah, and the big advantage of those kind of services, which again, Cision is one that y'all use, Meltwater, which is much more expensive, both Cision and Meltwater, that other agencies use, plus TVI's AG uses, it pulls off of closed captioning. So you can get TV clips and you can say, okay, our man Doug Richards did a story,
Okay.
And Doug always gets it right, but in a theoretical chance he got it wrong, I call him up and tell him he got it wrong.
Does it sort of evaluate whether they're favorable or unfavorable when you were mentioning?
It actually does, but when it comes to a prosecutor's office, it's completely inaccurate because it has words that it considers negative, like indict or prosecute or guilty, and so it doesn't have any way to judge it. At least it didn't then. Maybe it's improved, but it was kind of useless in the context of a prosecutor's office in that sense.
Did it give you any indication of what the earned media value was? When you're reporting that to your boss, where did you derive that figure?
It was part of it. As I think Senator Dolezal was referencing, it was part of the interface, the website. And again, I haven't looked at it since, my guess would be 2023. It would have a value, and it was frankly absurd. I mean, I would guess that it was probably put on there for, I don't know what the reason was actually, but it was sort of way to get like relative compared to other things I considered it, but it wasn't actually like an accurate presentation of some kind of, if you bought advertising, this is what it would be. It was sort of a feature of it that I think they put on there just to have people go, wow.
So that data that you reported up to DA Willis about the number of individual story mentions and the audience impressions and the earned media values info given to you by critical mention.
Yes, it's a website, a subscription website, and you do a search of some sort, and it would say here's the mentions of that term, here's the number of impressions, and here's the value, quote unquote. But the value is not in my opinion, I think other people share it, is not a credible number. I mean, it's in there as, I don't even know how they derived it. And again, I'm telling you, this is the 3+ year ago version of it. It may have changed since
Right.
then.
So when you earlier testified that you didn't think she really cared, was that about the value of it or whether it's positive or negative press about her?
I don't think she cared that much about the entire topic about press coverage. I mean, I think she wanted to have certain things out there so people understood what she was doing on their behalf, as well as people who might, again, the gang initiative. There was a concerted and successful effort to communicate that Atlanta was no longer a place to go be a gang member and get away with it, which it had that reputation when we got there. And I think that was part of why the crime rate was where it was when we took over. She took over. I should amend that. I didn't take over. But
Well, you're on the team.
Okay,
Yeah,
fair enough.
It's okay.
I'm a staff guy. I'm not running for office like you, but the principal always gets the credit. But it was we were making a concerted effort to say, in that case, and gangs being the most prominent and the one I remember thinking the most about and talking the most about, saying, this is not what it used to be.
Were you heard, speaking of running for office, were you her general consultant for her reelection campaign as well?
No.
Somebody different did that?
Yes.
Did she ever discuss with you running for any higher office, governor or anything?
That's beyond the scope of this. I'm instructed not to answer that. I object to it. I don't see there's any way you can fit that into anything that's on there, and I'm instructed not to.
Well, it's real easy. If you are tracking your media impressions, the value of it, whether it's positive or negative, and you are looking to run for higher office, as she has been quoted as saying she was considering running for governor, you may be talking about prosecuting for political gain rather than more legitimate purposes.
I'm instructed not to answer. And if you've got any good faith basis for that, lay it out.
I mean,
Don't answer.
okay.
Respectfully, counsel, I think the senator just laid that out, as did the committee's good faith basis, as to the public's faith and confidence in the impartiality of our district attorneys, as to whether there's political motivation. That's all listed in the recitals that you and I discussed earlier. I think it is related to the matter.
I'm gonna stick with it. It's not, this is not, this is turning into a political discussion, and if you've got any good faith basis, then lay it out. Otherwise, a district attorney is not required to be fair and impartial. A district attorney is an advocate for the state of Georgia, so that basis would apply. But there's no use in arguing. I've instructed not to answer. If you want to seek to enforce it, we'll take appropriate action.
Mr. DiSantis, are you familiar with the professional rules of conduct of the state bar?
I am.
You familiar with Rule 3.8 that governs prosecutorial attorneys' conduct?
I am, but if you want to, since I'm sitting here, if you want to quote it to me, I'll be happy to.
Doesn't it essentially require impartiality?
I would want to review the rules language before I answer that question.
So that's a fine answer. If you don't know, just say you're not.
I know the rule, but I'm not going to speak to it without having it in front of me.
Back to the critical mention, you discontinued the use of that. I didn't follow the reason. I heard you say you kind of regret that you're having to do it yourself now. It's tough.
Yeah, I mean, I think, sorry, my apology, for my apology to the court reporter. Yes, I wish we still had some equivalent thereof. I think at the time, when I decided not to renew it, I recall being slightly annoyed at them about just negotiating and sort of not wanting to deal with whatever it is they wanted for it. I don't remember precisely. And mentioning them that I'd heard that other people were paying less. But I think I'd already decided that, we were going to do something else, which I just haven't done. But I do think it's an important thing to have. And, we've been able to do without it, but I think we'd do a better job of tracking it for the reasons we need to track it with some program like that.
So the annoyance was over the cost of it or the relative charges you were.
Yeah, that's my recollection is I had an interaction with somebody maybe by email or by phone saying, I don't think it was by email, I think it was by phone, just saying, I heard other people paying less, like why we, I've been negotiating with you guys. And then it was just one of those things where I just didn't feel like fooling with it, all the other stuff I had to going on at the time, and I let it go and haven't taken it back up.
Been several years ago now since you've used them?
Yeah, there's only been those 2 annual contracts. I don't remember the exact dates of them, like what the dates were inclusive of. But again, it started at the beginning and would have been, sometime in the beginning of her tenure as district attorney.
Are you aware of any other district attorney's office that use critical mention or similar services? You mentioned a lot of agencies of state government.
I have not. I don't have any specific in my head, but I would be willing to wager that yes. So I mean, maybe I'll do that research. I just don't have time to do that before I get out of here.
You made some comments about the use of the special purpose grand jury for the subpoena. Is there something special about a special purpose grand jury that allows the issuance of subpoenas that a normal grand jury cannot do?
Well, you may be aware, and I actually know this from outside my tenure in the DA's office, but I do know this from inside because I explained it to members of the press at the time, including national press who weren't familiar with Georgia's particular rules. A regular grand jury is not supposed to operate without an indictment on the table. A regular grand jury, it's not like a federal grand jury or what most states are. You cannot run a grand jury investigation with a regular grand jury unless we have an indictment and we need to talk to this police officer before we true bill it or no bill it.
But they issue the indictment.
That's the issuing. That's a regular indicting grand jury, which we run 2. I think we're the only county that runs 2 simultaneously. We have one on Monday and Tuesday and one on Thursday and Friday because our caseload's so high. It started with a backlog, but we've continued it. So you got to use a special purpose grand jury. Now, I do think, and I remember having this conversation with different reporters on background, explaining to them the differences in Georgia. I believe Georgia repealed repealed grand jury, or it constricted grand jury's ability to do stuff. Regular grand juries, they created a special to do investigations, which, as you know, cannot indict. I think there was a Gwinnett case where the Gwinnett district attorney tried to use a special purpose grand jury to indict the people that he had investigated with it, and
I
that
think
got
DA
tossed.
Porter talked to us about that.
Yeah, and that got tossed by the Supreme Court, I presume. I don't recall exactly who did, but it was found to be. But for whatever reason, Georgia has decided you got to separate the two processes, and there may be very good reasons for that. Obviously, it creates a different level of work at some level, but it's, maybe good to have you got a report here where they wanted 39 people indicted, the office, went forward with 19, that, got a fresh look at it, and they indicted the 19.
And they did that through a regular grand jury.
Yes, as you were required to do.
I just didn't understand that I'm going to just call it a standard grand jury didn't have the power to subpoena.
It does, but there has to be an indictment on essentially before it to subpoena relative to whether to true bill that. You can't do like a federal grand jury can, or like most states can, where you can do a grand jury investigation and issue subpoenas and decide whether you think it's time to go draft an indictment and then come back and try to true bill. It's got to be two separate entities. I think there's case law on that.
There is. A regular grand jury has to have, it can subpoena, but it has to have either a special presentment or a general bill laying before it can subpoena.
That's all the questions I had. Thank you, Mr. Chairman.
All right. Thank you, Chairman Cowser. Leader Jones, any follow-ups from you? All right. Mr. DeSantis, thank you for being here today. Governor Barnes, thank you for being here as well. The committee is going to go into recess.
It's going to be Nathan
until
Wade
1
time.
p.m. We'll be back at 1 p.m. and we have Mr. Wade scheduled to testify at that time. Thank
He
you.
is discharged from
Roy Barnes is sitting
sir.
for his answer.
Thank you all.
All right, so we're going to be able to skip the break. Before we do that, let's show Adventure Aaron some love in the chat. Right as we had that line, and let's run that back one more time because I can't believe it. And of course, I had to clip it because, I doubt that they'd remove anything from this stream. But the last time I found a very interesting Fulton County, well, I didn't find it. It was sent to me. But I clipped it and it disappeared. So, wanted to make sure we clipped it. I still can't believe this. I'm going to be stuck on this all weekend. I'm going to wake up at 3 a.m. and be like, they really said that these major cases didn't divert resources, didn't contribute to a backlog of other cases. So let's run this clip.
I mean, she could tell you off the top of her head because she rides everybody in that process to get them dealt with, but I don't have the number in my head.
Have the resources that were spent on the election integrity cases and the Young Thug case sort of added to the backlog by diverting resources on those missions?
No.
And very quickly, with like a snap of the fingers, Adventure Aaron's like, here's 3 articles about how it took resources and sent them somewhere else. So, from Jacobin, if that's how you pronounce it. I've only ever had to read it. I don't know how it's pronounced. Maybe it's Jacobin. While Fulton County goes after Donald Trump, it leaves thousands languishing in jail. So there's a picture here in front of Rice Street. Does it say when this article was? These are older articles, you guys. The URL says 2003, August 2003. But I don't see a date up at the top, so around that ballpark. Democrats are calling Fulton County, Georgia District Attorney Fani Willis a national hero for her high-profile case against Donald Trump. Meanwhile, thousands of incarcerated people live in squalor in Fulton County jails, some dying without a day in court. So there's one. We also have from the Atlanta Journal-Constitution. As YSL trial dragged on, justice for other families was put on hold. Dozens of cases delayed as high-profile trial tied up defense lawyers, court calendars. And shout out to Joseph Papp, who's no longer with AJC. And when he left, I canceled my subscription. So thank you for doing the archive link here. For Sharidian Turner and her siblings, the 6-year wait for justice, 6-year wait for justice in their mother's murder was excruciating. The prosecutor's case against the man accused of killing her mother, Tanisha Evans, was delayed multiple times, first by COVID and related court shutdowns, and then because the accused man's defense attorney was tied up in what would become the longest-running trial in state history. We have a quote that says, "We were expecting to go on with our lives as if the system hadn't failed us, as if the loss of our mother was a wound that kept getting reopened every single time her case was pushed aside," Turner said. It was a clear message that was sent. It was if your case doesn't come with headlines and public interest, you'll be pushed to the back of the line. Which is why I think this critical mention thing, the timing of it is particularly interesting. So, and we know that the case dragged on. It was like 1,000 and some days. It ultimately ended up taking. I'm still not sure that the YSL case is formally closed, but we'll see. We'll see about that. We'll see if things change. You guys should all know Keith Adams, Jeffrey Williams, Brian Steele by now. Fani Willis declined to comment specifically on the YSL trial because there are 3 defendants whose cases still hadn't been heard at the time of this writing, which I don't know when this was, because the archive says 5 hours ago. I don't think this was 5 hours ago. And then we have Rolling Stone. So very quickly, Adventure Aaron turned this over. I'm sure there's more commentary out there about the impact that the resources spent on these 2 trials had on the other trials, or people that were waiting for charges to be brought, perhaps. So, I'm a Georgia law professor. This is Anthony Michael Crease. The YSL trial was a drain on everybody's resources. This is December 4th, 2024, right after the resolution of Trial 1. Oh, and it's paywalled. You guys get the point. This is just a quick little detour here. But yeah, like, what a frustrating thing for someone to just decisively say no. Just plain no, period. That these 2 cases didn't contribute to a backlog. So, yeah, Governor Barnes needs a nap. I need a nap. Coke Fairy says, utter BS. Glad you joined so I could rant about this again. I figured you'd appreciate that. We've got, YPCOM Shake, the judge herself. Judge Whitaker even said it during one of the trial days. So, crazy. It's a lot, you guys. All right, and then Aaron gave some dates here. The Jacobin article was August 26th, the Rolling Stone was 12/4, and the AJC one was March 27th, 2025. So, and that's when Demikian Garlington, Demise McMullen, and Christian Eppinger still had pending cases. So, there we go. Yeah, a trial that took up to 3 years for an acquittal, and please, you sit there and say it didn't affect anything with a straight face. Like, that's a lot. So guys, the cool thing, I am very glad that we got to watch Jeff DiSantis' testimony with attorney Roy Barnes sitting right there. That one little bit, I think, was well worth that entire watch, just to hear him say no about the impact of those 2 trials and the resources that it took to prosecute them. We get to skip the long break. We're going to get right into Nathan Wade. Let's see. Oh, that's a long break. There we go. And it looks like, because I believe this is over now, it looks like it'll be about an hour and a half to get through Nathan Wade's testimony, unless there's like dead air at the end. Yeah, it's about an hour and a half. We're watching on 1.25. So that's what we've got in store. After this stream ends, I'm going to take a little bit of a break just to get some lunch, and we're going to talk about the Afro Man trial. So Afro Man is the defendant in a defamation suit that a bunch of police officers are bringing against him for using their likeness and defaming them after he made a music video using footage from his own security cameras when the police raided his home. So we're going to read some motions because the video that started all of this controversy, Lemon Pound Cake, the music video, they filed a motion in limine, the plaintiffs, saying that music video should be excluded because it's not relevant to their claims against Afro Man or any of the possible defenses that Afro Man could raise against their claims. It's just, it's incomprehensible to say that the music video at the heart of this isn't relevant to the claims itself, let alone any possible defenses. So we're going to look at the most recent amended complaint, that filing. We're going to look at some, what is it, Trinity White Knights? I don't know the exact, but it's some type of KKK affiliation. There's some exhibit that the defense wants to admit, and the plaintiffs are also fighting to admit that. We're going to see if we get more context on whatever that might be. And yeah, I think that's going to be a fun stream. So just so you know, that's coming up later this evening. That trial is, I think jury selection might be on the 16th, but the first date I see for trial is March 17th, St. Patrick's Day. Gotta wear green. So that's going to be next week. Don't know if there will be cameras in the courtroom, but we'll cover it through whatever information we can find. So here we go. Let's get to Nathan Wade. Oh, play button. Can't tell the difference between play and pause. Yeah, Celestine, there's like 3 different channels where this can be watched without commentary. So I guess unfortunately, I mean, I'll put a poll up. We'll let the chat decide. And I won't be offended. We'll do whatever the poll says. Should I stop commentary? There we go. A poll for Celestine.
I want to recognize Mr. Nathan Wade has joined us. Thank you for being here, Mr. Wade. You're joined by your counsel, Mr. Evans. And then, Mr. Barnes, are you serving as counsel? Are you hanging out? What's your...
I'm hanging out, but I'll say that I serve as co-counsel in case I won't say it.
Would Mr. Wade say that you're serving as co-counsel as well, or is that a... So I do want to thank you for being here today. A couple of things before we get started, and then we'll swear you down if you've had a chance to view any of the other proceedings. We've been charged by a Senate resolution, essentially, to look into really a couple of things now, but as it relates to the Trump election interference case. We've taken testimony from a number of folks, actually, not just folks you work directly with on the case, but people, legal experts from around the state. And that's going to be the scope of what we're going to ask you about today. And the goal for us is to see if there's any steps that we need to take to reinsure public confidence in the justice system. Chairman Cowsert brought, what do you write, Chairman, 5 separate pieces of legislation so far? 5 pieces of legislation. I think you passed 3 of them out of the Senate. So that's really the goal of what we're trying to do here today. To the extent that you want to discuss anything with your counsel, obviously you're more than welcome to do that. I do have a mic control here, just like we did this morning for Mr. DiSantis. As I see you two talking privately, I'll just mute the mic so nothing gets picked up by the media. And so if you hear me say you're muted, that's what I mean, and I'll unmute. If you want to ask me to do that, I'd be happy to do that. But I'll try to just kind of toggle that as I see you guys discussing things privately. I'll open up with a line of questioning, maybe take a break depending on how long we go. Leader Jones has the option to do so as well. And then Chairman Cowsert had asked some questions previously, and obviously that would be at his discretion as well. Did you have any questions or anything before we get started?
I don't have any questions, but I do have an opening statement I'd like to read into the record.
Sure.
Good afternoon. My name is Nathan J. Wade. I am here on my own volition after accepting service of a subpoena from this committee. I'm a lawyer in good standing with the State Bar of Georgia.
All right, so the poll says you guys want commentary. So my commentary here is, why are we reading? I thought you kept everything in your head, Mr. Wade. So here we go.
I served as a special assistant district attorney for the office of the district attorney of Fulton County beginning in 2021. Before accepting that appointment, I worked as a prosecutor, ran a private law firm, and served as a municipal court judge for over a decade. For my appointment as special prosecutor, I swore an oath to follow the law. I took the oath with solemn pride and responsibility. I did not accept the position to financially reward or benefit anyone, namely District Attorney Fani Willis. My team and I investigated the state of Georgia versus Trump et al. For approximately 2 years or more. The investigation was not politically motivated or influenced. Rather, it was an independent investigation based on facts, interviews, evidence, and the rule of law. I was not directed, ordered, asked, coerced, pressured, or importuned to bring any charges in that case. We simply went wherever the evidence led us. No one at the White House counsel's office, the Department of Justice, or the January 6th committee directed, ordered, asked, coerced, or importuned, or pressured me to do anything in that case. I did not violate a single rule of professional responsibility in the Trump case. I did nothing to compromise the integrity of that investigation. After a thorough and independent investigation, we presented our evidence to a special purpose grand jury. In August of 2023, the grand jury returned indictments against 19 people, 4 of which entered pleas of guilty, and rightfully so. In January of 2024, the co-defendant moved to disqualify D.A. Willis and myself from that case. The court held a hearing during which I testified, was cross-examined by each defendant's attorney, and the link to that public testimony will be made available by counsel if anyone needs it. On March the 15th of 2024, the court denied the motion to disqualify. In that order, the court allowed the Trump case to continue only if DA Willis's office resigned or if I resigned. Later that day, I voluntarily resigned. Since then, I have had minimum contact with the Fulton County District Attorney's Office, and I have had no access to documents or evidence kept there. Based on your assertions to my counsel, the committee agreed to limit my testimony to an hour. The committee also agreed not to ask about any personal relationships or any pending or current investigations and prosecutions. I request that we honor that agreement, and my counsel will object if we do not. Please remember that my knowledge about many topics is limited because I have not worked or been contracted at the District Attorney's Office, Fulton County, since I resigned in March of 2024. Also, many of the events happened years ago, so I may not remember specifics. Further, I am bound by attorney-client privilege, confidentiality agreements with the Fulton County, grand jury secrecy rules, and Georgia Rules of Professional Conduct 1.6a, which requires me to maintain in confidence all information gained in professional relationships. I am here to cooperate. I will answer questions to the best of my ability, but within the confines of professional and ethical responsibilities. In that light, please allow me to further read into the record this notice and general reminder that I've received from the Fulton County District Attorney's Office regarding my position. It says, "Dear Mr. Wade, I write to you in my official capacity as District Attorney for the Atlanta Judicial Circuit and on behalf of my office regarding a recent subpoena that you received from Senator Bill Cowsert and Lieutenant Governor Burt Jones requesting your testimony before the Georgia Senate Special Committee on Investigations related to your former contract or employment as a special prosecutor with the Fulton County District Attorney's Office. The subpoena does not provide any indications of what matters or information your testimony is expected to involve, but given the focus of your work as special prosecutor, I expect that your testimony will relate somehow to our office's pursuit of accountability for the unlawful attempts to overturn the 2020 presidential election in the state of Georgia. To make clear my official position as District Attorney, I write to remind you of your continuing obligation not to disclose any confidential information related to this office's criminal investigations, including information that is protected from disclosure by grand jury secrecy rules or applicable legal privileges held by this office. To that end, this letter serves as formal notice that the Fulton County District Attorney's Office is asserting all applicable legal protections and privileges over information you have obtained as a contractor of this office. This includes knowledge of key evidence, confidential attorney communications, discussions of legal theories and analysis, prosecutorial recommendations and deliberations, as well as knowledge of the sources, procedures, and techniques employed. Last year, when your testimony was sought by Congressman Jim Jordan of the Judiciary Committee of the House of Representatives, I wrote you a similar letter, which I have attached. This letter serves as the same purpose, and the office asserts the same protections and privileges. In their absent attempts to serve the desires of a few individuals rather than the rights of millions of Georgians and to discredit the good work of our office to defend the rule of law, members of the committee have recently subpoenaed me as well. My objections to these latest efforts remain the same. I am concerned that questions posed to you by the committee could implicate several significant established privileges and confidentiality interests. These include preservations of the secrecy of grand jury proceedings, which is well-recognized principle in both federal court and the courts of the state of Georgia. Attempts by the committee to solicit information from you about evidence in the election interference case would run afoul of these fundamental principles. Additionally, questions about the substance of your work in this case would also seek information that is protected by the deliberative process privilege, attorney-client privilege, and work product privilege, among others. As Chief Justice John Roberts has observed, it has long been understood that recipients of legislative subpoenas retain common law and constitutional privileges with regard to such information. The site is Trump v. Measures, USA. It is the responsibility of the FCDA and its employees to protect secret grand jury information or information that is privileged, confidential, or sensitive. As former appointed special prosecutor for the office, this is your responsibility as well. Any protected information would belong to the office, not to you personally, and accordingly, you should refer the committee to this office regarding any such information. As you are undoubtedly aware, the sharing of non-public privileged information violates Georgia professional ethics rules, including special rules applicable to prosecutors. Such disclosure can prejudice defendants, victims, or witnesses, or affect the overall integrity of the proceedings. I know that you intend to comply in good faith with all proper legal requests related to your work with the office. Although I'm sorry that you are forced to deal with the ongoing efforts by others to attack the legitimacy of your work, I thank you for your steadfast compliance with the law and for your adherence to the claims of privilege laid out in this letter. I believe that the efforts of Senator Coward and Lieutenant Governor Jones and the never-ending investigations into the FCDA by them and by others, such as Congressman Jordan, are a part of a transparent and shameful campaign to use the force of government to harass, silence, and punish those who have been brave enough to stand up to Donald Trump. No true public servant deserves this kind of public harassment for their work. As I have previously indicated, I am grateful for your work as a special prosecutor and your commitment to the highest ideals of American democracy. Yours in service, Fani T. Willis, District Attorney, Atlanta Judicial Circuit. Copies of this letter will be provided through counsel as well.
Thank you, Mr. Wade.
I stand ready to respond.
I'd like to go ahead and swear you in, if that's okay. If you could raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. I do want to clarify, and Mr. Miller, maybe you can weigh in on this. I did not believe we had agreed to a time frame for this testimony. I certainly don't want to be here longer than we need to be, but I do want to just make sure that we're all on the same page before we start with that.
Yeah, not to my knowledge, I'm happy to discuss at our first break, but just for context, our earlier witness was started at about 10:30 and we were finished before noon, so I don't expect
yeah.
really
If we
much
go over a
beyond
little bit,
that.
that's fine. I talked to Josh Belfonte about restricting it to an hour, so
Okay.
that was my understanding on all this.
I certainly think that I'll get through my stuff with under an hour, I hope, and then we'll see. Maybe we can break and see how much time we think we have left. Mr. Wade, thank you for that opening statement. It kind of gets to a little bit of your background, and so I don't want to belabor that too much. I think some of that's also just kind of been out there in the news cycle over the last couple of years. So given our time restraints, I don't want to spend a ton of time on that. I do want to just get into a couple of things that the committee's talked about over the past couple of months. But first and foremost, if you could walk me through your process of being hired. I understand that there was some taint work that was done, I think, by your firm, and then maybe a firm that you have some partners in, and then that kind of transitioned into you working on part of the transition team. If you could just lay that out for us, and if you could get us all the way through to being appointed as special assistant district attorney, that'd kind of be as far as we want to go with that.
So, no, sir, you outlined two separate processes. I had nothing to do with doing any taint work with the Fulton County District Attorney's Office. Those contracts were held by two other lawyers, nothing to do with myself.
Okay.
My appointment to becoming a special prosecutor dealt with my familiarity in terms of being a municipal judge and Ms. Willis being a municipal judge at the same time. We developed a sort of a mentor-mentee relationship over that course of time.
Great. Walk me through the work that you did on the transition team. I think that you were part of a transition team, as I understand from Ms. Willis's testimony, between her election and her swearing in. If that's accurate, walk me through it. If not, correct the record for me.
So briefly, I was a part of a transition team. I didn't officially participate in all the work that transition team performed. I was continuously a part of an unofficial advisory committee, if you will, with her.
Okay. And there was, at some point in time, there was a search committee that was formed. Mr. DiSantis mentioned that this morning. D.A. Willis discussed that as well. There was a search committee that's formed essentially to look into someone to lead the Trump election interference case. Is that correct?
Yes, sir.
And you were part of that transition team. I'm sorry, you were part of that search committee.
I was.
Is that correct?
I was.
Who else was it? Was that an official committee that had named members, or was it more of an ad hoc committee?
No, it wasn't. I don't really recall the specifics of how it was put together, but I do recall taking part in doing the work. I couldn't tell you who else was all involved, but I know that she was taking advice and counsel from several other sources.
Do you remember approximately when that work began?
I don't. It was after she had won the election, obviously.
Okay. The meetings that you had that you were a part of, do you remember anybody else that was a part of those meetings besides the district attorney?
I don't recall if, I seem to recall that all the meetings had different members, so there was never a set group of people that met in that regard. And so because of that, I'm having a difficult time recalling.
Do you remember any either formal or even casual interviews for candidates that would be a potential special assistant district attorney?
I do.
Could you tell me more about that, please?
Well, Governor Barnes might be able to answer that a lot better than I would. He was one of the individuals who was asked, I wouldn't call it an interview, asked to step into the role.
And he turned that down, as I understand it from previous testimony, due to his ongoing caseload. He had some current concerns about the publicity and security concerns that may come along with that case. Do you remember anyone else that the committee either talked to via a formal interview or informally?
Yeah, I recall. I recall Attorney Gabe Banks being asked to step into the role as well.
Officially offered a role, and he turned it down as well?
Yes.
Okay. Was there anyone else that you recall that you talked to that turned down the role or was never offered the role?
I don't understand the question.
Was there anyone else that the committee approached about the role?
There were other people, other candidates. I do recall D.A. Willis being very deliberate and careful about whom she selected for the role. There were lots of people who were sort of applying or wanting to do it because they had political agendas one way or the other, and she was astute enough to sniff those things out immediately and disqualify or do away with those particular candidates. But specific people, I don't recall.
Okay. Do you remember approximately when the focus turned to you as a possible candidate?
I don't remember in terms of time, but I can recall because D.A. Willis either was not satisfied with those who were applying to do it, or those whom she approached to do it had said no. She asked me to do it. Initially, I said no. I had no desire. Now, had I, in hindsight, I probably would have gone and had another conversation with Governor Barnes to get some specifics about his concerns, as opposed to going through the deliberative process alone. But I did, and ultimately, I accepted the position.
I'm curious why you didn't have a desire. It's a high-profile case. You're an accomplished attorney, doing various work both as a judge and as a lawyer. This seems like something that would be a pretty good opportunity. Do you recall why you didn't have any interest in doing it at that time?
Yeah, I do. I rather enjoyed serving as a municipal court judge. One reason would be I would have to step aside, take a leave of absence from that position. The other reason was my firm at that time was doing very well, and I didn't want to step away from that work. The pay obviously was not very good. I don't think anybody can debate that point. And the subject matter, candidly, just didn't get my attention.
What caused you to change your mind?
After having more discussions with D.A. Willis and having more discussions with those that I look to for advice and counsel, and I have a love for different areas of law, and this was that for me, so I did it. Okay.
Do you remember if you remember even the month, that'd be helpful, the month at which you officially started in that role?
I don't.
Okay. You served in that role up until 2024, is that correct?
March.
And it would be best described, I believe that the DA described it this way, is that you were essentially the lead of the team that was working on the election interference case.
Yes, sir.
Okay. I want to ask a couple questions that have come up, and this is one that you've seen it discussed, I'm sure, as it relates to the billing. There's been some discussion of this block billing, and this is just an example. This is one of the invoices that you submitted. I believe that you testified that on occasion you would submit invoices and you would receive questions back from the DA's office. There'd be some adjustments to the invoices. Is that correct?
So I don't know if the questions would come from the district attorney's office or they would come from the accounting department within Fulton County. But I would get the question and I would respond to it.
Do you remember was the nature of those questions relative to essentially the tabulation of the invoice, which would make sense for it to come to accounting, or was it more so around your description of work that you have listed on the invoices?
No, I don't recall the nature of the questions.
Okay. It was stated under testimony of the district attorney that was her opinion, or at least her position, that oftentimes you work more hours than you billed. Would you agree with that assertion?
I would agree with that.
Help me understand kind of how the tracking process worked, given that, and were you on a cap of some sort, I believe, in your contract? There was a maximum total billable dollar amount each month, and you obviously couldn't bill more than that. As it relates to these invoices for 8 hours, would you say that the majority of those were 8 hours? Would you say that some large percentage of them where you went over on time but only billed for 8 hours? I think that you would agree that it's unusual to see kind of that rounded billing. We've looked at in this committee other billing from people like Anna Cross that worked on the same case, and this is just one example of one of Ms. Cross's invoices, and they're down to, it looks like, the 10th of the hour. So walk me through, essentially, help me understand the block billing, and then I want to get a further understanding, if you could, as to how many days you think you went over. I see on the right-hand side there you did bill for, you kind of have multiple days covered, 12 hours across 2 days, that kind of a thing. So I just want to understand the billing. If you need a more specific question, I'd be happy to ask it more specifically, but I'd just like to understand your perspective as you've heard the commentary around the billing practices here.
Yeah, so it's simple. If you take a look at the bottom of this invoice specifically says submitted the 31st day of August 2022. Look right above that line. It says, due to billing restrictions, this invoice has been significantly truncated, which means that I was not allowed to bill over X amount of hours. That does not mean that I could complete the task. As a matter of fact, I can tell you for a fact, I could not complete any task in the amount of time that I was allowed to bill. So the way that you see those bills, each and every one of those bills has been truncated.
I'll go back to this one just because it's probably easier for us all to read. What do you mean by that when you say that each and every one of them is truncated? Do you mean essentially the total is truncated, or do you mean each entry is truncated?
Each entry. The first entry there, you see 4.3. Now, that's in 2023, and I don't remember what that was even about, candidly. But I can tell you that if I billed 8 hours, it probably took me 16 to do it.
Okay, so on 4/13, you're working more than 8 hours that day. 4/3, 4/4. Then the 3 day span.
So sorry.
No, you're okay. Go ahead.
If you look at the top portion of that billing invoice where it says description in the blue, right next to the word description is date completed. So the dates that you're seeing are the dates that the task was completed. That is not the date that the task begun. So if you see 8 hours and there you see 8 hours.
Okay. The top line says meeting with team completed. Wouldn't that mean that you had the meeting on and before that day, maybe? For like the line below, it says meetings, plural. Like, why would, I guess, comma research? But this has a date range. So why would you use single dates for some, but then use date ranges for others? Just trying to think it through. I don't see how that's a plausible explanation here based on what else is in this. And the alternative explanation to that answer not being truthful is your billable hours are very sloppy and misleading and disorganized, which is problematic too, although maybe not rising to the level of a blatant misrepresentation, an intentional misrepresentation. But this doesn't add up.
Billed. It was completed on 4/3. I could have started that task.
Yeah, it's not
2
fun.
days prior.
So that first one, there's a meeting with team, comma research. So obviously a meeting with the team is a day, I would assume. Are you saying that you're having multiple days of?
Listen.
I know you don't know the specific. I'm just saying, let's just pick that one out as an example.
That's great. That's a great example. I will tell you this. That team and I probably met in one day, probably 6 times in one day. And that's a small frame. We were constantly meeting because we had a lot of evidence and a lot of work to do. So, yeah, that's a great example. Thank you for pointing that one out.
Because for the most part, I believe you testified to this, more or less you were going into an office. You weren't working from a Cobb County, Marietta office. You were working out of some office. I know we won't disclose the location, but there was an office where you were going to work with the rest of the team was working out of.
Absolutely.
Okay. Great. One of the things that the committee's discussed is the accounting here indicates that not all of your bills, but some of your bills are paid out of county forfeiture funds. We've taken testimony in this committee around the use of forfeiture funds. Did you have any knowledge that you were being paid out of forfeiture funds?
I don't even know
Is
what
it-
forfeiture funds are, sir.
Okay. So forfeiture funds there's a split, as I understand it, where essentially criminals have their property seized, that property is sold, that a percentage of that money goes to the sheriff's office, the bulk actually, that money goes to the sheriff's office. Was it 10%, Mr. Chairman? Flows down to the DA's office. There's some examples here where you're paid out of, out of Fund 100, which is the general fund, and then some that was the forfeiture funds. I didn't know if you were a part of any conversation around different sources of funds, or if you were just sending an invoice and a check came in whenever it came in. Obviously, you're not reviewing that check probably to see a fund number on it.
So, first and foremost, I have no knowledge of what this document is. I've never seen it. Secondly, once I submit an invoice, if there's not a question about the invoice, I expect payment. Now, albeit when I received the payment, it was most of the time 2 or 3 months later. So I have no clue where the funds came from, what fund was used. I would.
Do you recall, one thing that we received testimony on from somebody who works with PAC, I believe, was that one of the limitations that he referenced as it relates to forfeiture funds is you're not supposed to be able to pay anyone more than the prevailing rate of a county employee. And that's about $75 or $80 an hour in that ballpark for the district attorney's office hourly rate for a county employee. Obviously, your contractor rate was more than that. Was there any conversation that you recall about a need to adjust a rate because you were being paid out of forfeiture funds?
Never.
Okay.
Now, I have a need to adjust my rate. Obviously, I'd like to be paid at my normal hourly rate, not the pennies that I was paid, but never.
Okay. You testified, I believe, to Mr. Jordan's committee, is that correct? Congressman Jordan's?
Yes.
And there was some testimony there relative to the start of the date of the search committee. And we've kind of gone around it on this a couple of times, but I do just want to understand it because I think that your testimony seems to indicate that those conversations were taking place.
Sorry, what are we looking at here?
This is a section of the, I guess it was a deposition before Mr. Jordan's committee. Back in 2024, I believe was the date of that. And really what I wanted to get to was here.
I don't know if you signed it. No.
You want me to pull up the full document? I can pull the full document, that's easier. I just pulled a screenshot here. But you were asked, and so the search committee, you said it began when DA Willis took office on January 1st, 2021, is that correct? Yes. And there was outreach to you to be part of the search committee prior to January 1, 2021, absolutely. When did that start? Sometime after the election, but prior to her taking office. Now, you told us today that it was sometime after the election, so that's consistent. Is it your recollection that it was also prior to her taking office at the search committee?
So I'm going to need some context here because, and I don't know if anyone has shared this with you, she had actually formed several search committees. There were committees to fill her office staff. Are you referring to that?
No, and I'll pull up the context for you here. It's going to be a little bit harder for me to do it, but let me just try to get this over on the screen here. I'm going to try to... This top part actually is you talking about the interesting legal issues with the case and kind of what we just covered. And so the search committee, you said DA, this is what I just read, you said DA Willis took office on January 1st, is that correct? Yes. And was there outreach to you to be part of the search committee prior to January 1st? Let's go up to see what search committee we're talking about. So January 1st, I was part of the search committee for the newly elected district attorney, and we were tasked with trying to identify someone who would serve as lead counsel on the election interference case. The goal or trick was to make certain that the individual selected was one who had no axe to grind, if you will, which you just said the same thing here. 3 to 5 candidates, you said the same thing here. You referenced Mr. Barnes, so we cover all that. So we're in the context here of the search committee for someone to lead the special, the Trump election interference case. And so you talk about people turning it down. Governor Barnes turns it down. You referenced the same thing you just did. You didn't get enough credence to his warnings. And so the search committee that you said began when DA Willis took office on January 1st. Is that correct? Yes. And there was outreach to you to be part of the search committee prior to January 1st, 2021. Absolutely. And when did it start? Sometime after the election, but prior to her taking office. Okay, so between the election, and you're referring to November 2020 election, is that correct? Yes, ma'am. So when you had the conversation with individuals, you said on multiple occasions, you said no and turned their positions down. Who were those conversations with? And so I want to go back up to this, and the question I want to get back to is you testified today that it was sometime after the election that you were part of the search committee for the election interference case. You mentioned here as well that was prior to her taking office. Is that still what your recollection is?
So, and I think she's answered this for you. You can't form a committee before an actual act has occurred. Respectfully, I just don't think that what you're driving at is possible.
Which act did occur? Because the indictment states that the conspiracy started in November of 2020. The Trump electors met at the Capitol in December of 2020, which that was in a time period between the election and her taking office on January 1st. Obviously, the electors being here was news. I think most people knew that had happened. Certainly was controversial. So the phone call that happened on January 2nd obviously happened after she was sworn in, but the actual reason that a lot of these people were indicted did indeed happen before she took office.
Are you telling me that, or what are we?
Well, I want to establish those facts. I would ask if you would disagree with any of those facts, and then given that, because your assertion essentially was that nothing had happened until after she was sworn in, and I would actually respectfully say that according to the indictment, it was actually the assertion of the indictment that things did begin before she was sworn in.
Okay.
So did the conversation happen relative to a search committee before she took office?
I don't recall.
You don't? I'm sorry?
I don't recall.
Don't recall. Okay.
So in the chat, I see, well, I don't know where it went. Yeah, Nicklin said, what is all this evidence? So I'll share a link to this in the chat. This is from a few years ago, October 15th, 2024. It's a deposition with Nathan Wade. So if you want to read the whole thing, it's 132 pages. I'll drop a link in the chat. I'll put it in the description for you guys. But that's what's up on the screen that they're looking at here. Where is... Oh gosh, where's the feed? I have a lot of tabs open. There we go.
I'll try to get back to this view here. Thanks for indulging me on that.
Yes, sir.
One last slide here. I gotta do this. This slide's from a couple pages later in the Jordan testimony. Did you have any conversations with anyone besides D.A. Willis regarding the special prosecutor role and Governor Barnes, I'll say, referencing what we've talked about? I did, and I'm trying to recall if that was, and there's a name that we don't know. He's the individual I had the conversation with prior to my being appointed, if you will, a special prosecutor. Did he work at the DA's office? Do you recall who that individual is that is referenced in the redacted section?
I don't.
And it says, okay, so you spoke with this individual prior to D.A. Willis taking office, and you said, I did. Does that help jog your memory at all as to conversations that may have taken place before she took office?
It doesn't.
Okay. This is a letter. I'll zoom in on this one as well so we can see it better. It was sent from Ms. Willis to, I believe, Congressman Benny Thompson, who's chairman of the Jan 6 committee. Have you seen this letter before?
It says 2021 on it.
I'm sorry, is that what I said, or I forget what I said?
Well, no, I'm just
Okay.
going through the process in my mind. It says 2021 on it. I can't remember. I'm searching for you, but
Sure.
I can't pull it.
He's
I can't get
searching
to
in
it.
his mind.
So it says, please accept this letter as an official request from me to access to records that may be relevant to our criminal investigation. Those records include, but are not limited to, the recordings and transcripts of witnesses, interviews and depositions, electronic and print records of communications, and records of travel. Do you recall there being conversations within the office relative to asking the Gen 6 committee for help relative to any of the things I just read off that list there?
I don't recall.
Okay. And that, you're right, that was December of 2021. This here, I'll zoom in so we can see this better. At the bottom. This is an invoice from 5 months later for a team meeting. Looks like a colon there. Conf with Jan 6, research and legal issues to prep what I assume is a shorthand there for interview. Do you remember a conference call that you had with the January 6th committee in April of 2022?
I do not.
Okay.
Now, certainly, I'm not saying that it didn't happen. I'm just saying I don't remember the call.
Sorry, hang on a second. I'm sorry, Mr. Wade, can you repeat that?
Sure. I said, certainly I'm not implying that it didn't happen. What I'm saying is I don't remember the call.
Sure. Do you remember any calls that you had with the Jan 6 committee?
I don't.
Do you remember any meetings you had with the Jan 6 committee?
I don't.
Okay. What was the role of the Jan 6 committee as you understand it?
I don't recall.
I'm not asking you to recall, I'm asking you what you believe the role of the committee to be.
You're asking me what was their role as it relates to
Just generally.
my
No, sir, sorry. I'll refine the question. As it refers to their existence.
Well, I didn't work with the January 6th committee, so whatever their role as defined by their organizers or statute is independent of anything that I would have ever done. So I don't want to sit and try and define what they were charged with doing because I had nothing to do with it.
Okay. I'll try to scroll up on this one here a little so we can see it higher. These cameras are blocking us. You're good. You don't need to duck down. It's just the actual camera. There's a entry here from about 10 days later. I believe it says travel. Look over here. Travel out of state, interview, and research. Do you recall specifically what that travel was?
I have no clue. That's 2022?
Yeah, it was a long time ago.
I have no clue.
Okay. I'm going to show you a Politico article here. Have you seen this article here before? It says Jan 6 committee helped guide early days of Georgia Trump probe.
I've not.
They state there in the subheadline, in the spring of 2022, the committee staff helped Fulton County prosecutors prepare for interviews with key witnesses. Do you recall either you or your staff working with the Jan 6 committee to prepare for interviews with key witnesses?
No.
Okay. In the body of the article, it says that committee staff quietly met with lawyers and agents working for Fulton County District Attorney Fani Willis in mid-April of 2022, just as she prepared to convene a special grand jury investigation. In the previously unreported meeting, the Jan 6 committee aides let the district attorney's team review but not keep a limited set of evidence they had gathered. Do you recall a meeting with the committee where there was access given to evidence that you were able to view but not retain?
I do recall that.
Okay. Can you tell me about that meeting? Do you recall where that meeting was?
That meeting was in Washington, D.C.
Do you recall if that was the meeting that is billed for here, now that you're?
I don't.
Okay. Seems to be in the same time frame. That trip happened in April. So obviously it says spring of 2022 here. So that was in Washington, D.C. Who went to D.C. with you on that trip?
I remember an investigator, but I don't recall specifically which investigator went. And I do recall that there were maybe 3 lawyers from the team, but I don't recall specifically who they were.
And that investigator would be from your team as well, one of the 5 to
Yes.
10 people y'all worked with. So 3 lawyers, maybe 1 investigator. Who did y'all meet with there? Do you remember?
An attorney.
Do you recall who the attorney was working for?
I do not recall her name.
You know it was a female.
Can we mute this for 1 second?
Yes, sir. You all good? Okay.
So, point of clarification.
Yes, sir.
Meeting with this lawyer, the young lady, she was not a member of that committee. This was an attorney.
And she was an attorney working for the committee?
I don't know who employed her, but that's who we met with and had the conversations.
Was there anyone else besides this attorney and your staff that was at this meeting?
I don't remember anyone else.
Okay. So this lawyer, you said essentially showed you all evidence, not help, but showed you guys evidence that had been gathered and did not allow you to retain that evidence. Is that correct?
That's correct.
Okay. Do you recall the evidence that she provided to you?
I don't.
Okay. Do you recall what interviews that followed that evidence was relative to?
I don't.
Okay. How long was that meeting? Was it multiple days? Was it 1 day?
I'm sure if you go back to the billing, it might tell you if that's.
If this is
the
yeah, we don't know if this is the entry or not, but if it was, I'm assuming this travel out of state probably has a good chance of being that because there's not too much travel out of state that you billed for. So this would appear to be 3 total days. You billed 16 hours, so it's not 3 full days. Does that help jog your memory on how long that meeting may have been?
Oh, it doesn't. No, sir.
Okay. The article goes on to say, over the next few months, committee staff also had a series of phone calls with Willis's team. They answered the prosecutor's questions and shared insights on matters like Trump's false electors gambit and his efforts to pursue Georgia Secretary of State Brad Raffensperger. Both of those ploys ultimately feature prominently in the criminal charges that Willis brought against Trump and his allies last summer. Do you remember either you or your staff being part of a series of phone calls with the committee staff?
I don't recall that.
Do you recall if you had any further conversations with the female attorney that you met with in D.C.? Were there any other phone calls or meetings with that particular individual?
I did not have any, no.
Okay. Are you aware whether your staff had any? Anyone working on that? When I say your staff, I'll use that loosely, your team that you were leading.
I understand. I'm not sure.
You're not sure if they did? Okay. And you do not know whether there were any phone calls with anyone else from the committee staff? Is that correct?
I don't understand the question.
The article here says the committee staff had a series of phone calls with your team. I just want to just make sure you said you do not recall whether your team had any further phone calls with any of the other committee staff?
No, sir.
About Gen 6 committee staff?
I don't know that it happened or did or didn't happen. I don't know.
It says the contacts between the committee and Willis's team also helped prepare prosecutors for interviews with key witnesses. Do you agree with that characterization?
I don't.
You do not agree with that characterization?
No.
Okay. All right, I'm going to the next slide here. This says here, Jan 6 Committee Chairman Benny Thompson had previously described, quote, staff-level contacts between his panel and Fulton County prosecutors. Does that help you remember any other staff-level contacts that were not inclusive of that one meeting with the attorney?
No, sir.
Okay. In early April 2022, nearly 2 weeks before the panel staff met with Willis's team, which does seem to then point to that entry that you did have on your billing as being the correct one for that meeting, Thompson told reporters he wasn't aware of how extensive those contacts were, and on Wednesday, Thompson told Politico that he did not know about the in-person visit that spring. So, did you ever meet with Benny Thompson?
No.
Representative Benny Thompson?
I never met with him, but it would seem that it makes sense. If he's saying that he wasn't aware, then perhaps the young lady, the attorney that we were talking about, wasn't even affiliated with Mr. Thompson. I can't put that together for you.
Yeah, I think he said what he wasn't. He says he wasn't aware of how extensive those contacts were, but certainly he says he previously described staff-level contacts, so he was aware. I think what he's saying he's not aware of is how extensive those contacts were. And I'm just trying to get a better understanding of how extensive those contacts were. Because I'm saying, in the meeting, members of Willis's team interviewed some of the committee's evidence on Georgia-specific matters, including Trump's efforts to pressure local officials and the fake electors' actions in the state. Do you remember viewing any such evidence with that attorney when you were in D.C.?
I do not recall what we viewed, sir.
Okay. It says here, committee staff had more calls with the prosecutors over the following months, including discussions of their conversations with witnesses with whom the prosecutors were planning to interview. The calls helped prosecutors prepare for those interviews. One witness they discussed was Pat Cipollone, Trump's final White House counsel, who spoke with the committee investigators just days before the meeting with Willis's team. Do you remember any calls that helped your staff prepare for testimony from Pat Cipollone?
I do not. I'm not certain who the author of this article is, but I'm certain that they would have no firsthand knowledge of what the content of any phone calls were or conversations in preparation to interview any witnesses were. We prepared as a team, we prepared ourselves for interviewing those witnesses, utilizing the evidence that was collected and gathered by our investigators and ourselves, our team itself.
Do you recall if your committee deposed Pat Cipollone?
I'm struggling to I mean, I recall there being some discussion around it. I don't specifically recall whether we interviewed Cipollone or not.
Did you sit in on most of the interviews or depositions?
All of them.
All of them. So if there was an interview or deposition with the president's White House counsel, you would have sat in on that?
I would have.
Do you recall that, if that happened or not?
I don't.
Okay. I'll go to our next slide here. I'll unmute you. Or sorry, you're muted. Y'all good? Okay. This is a letter on White House stationery. This letter Mr. Wade was part of an open records request that was just fulfilled about 2 or 3 weeks ago. America First Legal and Just the News had filed an open records request that was fought in court. I think that before there was a final ruling on that, there was 8,000 pages that were released. Some of those have been made public. This is one of those, just so you know the origin of this. So this is relatively new to the public record, but was voluntarily released by the district attorney's office. Have you seen this letter before from the White House to Mr. Donald Wakeford?
I'm not recalling, I won't say that I've never seen it, but if it's dated 2022 and it came to Mr. Wakeford, I'm certain that I was made aware of it.
We haven't talked to Mr. Wakeford. That's honestly the first time I've seen his name. This would appear that was he on staff with the DA's office, or was he a contractor?
He was on staff.
He's a staff member. Was he part of your team?
Yes.
Okay. Was he one of the 3 attorneys that traveled with you to Washington, D.C. to meet with the attorney?
I don't recall. I do know that he did do some travel. I don't recall specifically which trips Mr. Wakeford
Okay.
was on.
This is a 2-page letter. I'll show you the ending of the 2nd page, because what's at least somewhat significant of this, I think, as it relates to the investigation that you were a part of, is this is where President Biden waived the executive privilege with respect to testimony of former Trump administration officials before the special purpose grand jury, which would be your grand jury, or the DA's grand jury that you were helping lead, in connection with any inquiries related to the subjects in the prior paragraph. Does this help you recall at least the overall purpose of this letter? Do you recall executive privilege being waived by the Biden White House?
Well, based upon the letter that you've put up there, I mean, obviously it's about executive privilege, so yes.
Do you recall that executive privilege was waived as it related to the White House? President Trump's executive privilege was waived as it related to your investigation?
Yes, sir, the letter said it.
Okay. What witnesses did that give you access to that you would not have otherwise had access to?
I don't recall.
Would Cipollone be one of those?
Yeah, I don't recall which specific witnesses there were.
B.J. Pack could be the U.S. attorney that they call trying to.
Would it be your understanding that B.J. Pack would be someone whose privilege was waived here?
I do recall interviewing B.J. Pack.
Okay. Who else from the Trump administration do you recall interviewing?
Yeah, I'm drawing a blank. If you gave me a list of witnesses, I could probably identify.
Mark Meadows?
Mark Meadows.
Interview Mark Meadows?
Yes.
Cipollone, you already said yes to Cipollone?
No. I
We're
didn't.
getting pretty close into the substance of the investigation, so I just want to make sure that we're not.
Yeah, I mean, one of these is in a news article.
Yeah, if we're asking about newspaper reports and public documents, that's fine, but if we're asking about what went on in certain conversations.
Do you recall the event of privilege being waived, something that you were waiting on to be able to proceed with interviews of people that you wanted to talk to?
Pursuant to this letter?
Pursuant to, you would not have had access to them because privilege would prevent you from interviewing them. This letter comes and now you have access to them?
Yes.
Okay. Would you describe this as a significant moment in the prosecution that gave you access to those individuals that would help you build your case?
I don't think one piece of evidence is any more significant than any other. The evidence is what it is, and I wouldn't weigh any piece heavier than any other piece, so I wouldn't necessarily say that it's significant or not significant. It's just a piece of evidence.
It's my understanding that the purpose of executive privilege essentially is to prevent this kind of thing from happening, where the president would have the ability to adjudicate his duties and would be able to go to his counsel, similar to the way that we're all going to our counsel with privacy, and be able to get honest conversation. It would appear to me, at least, that the waiving of that by President Biden was significant. Do you recall, as it relates to Mr. Wakeford, talking to him about asking for privilege to be waived from the White House?
I don't recall.
Do you know if Mr. Wakeford asked for privilege to be waived from the White House?
Well, now you get into processes and procedures on witnesses, so I object to it on that basis. It gets into the deliberative process on whether.
Thank you, Governor. We got the objection.
Well, wait just a minute. I'm entitled to make the record. You don't have to tell me.
I think you've made the objection.
No, I'm entitled to make the record and make it fully.
Let's hear the testimony.
And say what?
I said, let's hear your testimony then.
It's just his belly and arms down here yelling.
Well, I resent that.
Governor, your objection is on
The objection is that it gets to processes and procedures of how the investigation went on. The question is, did Mr. Wakeford ask for and encourage the waiving of the privilege? That gets into a process or procedure of how the investigation was undertaken. can ask him whether, and you got the letter, you can ask him, did he request it?
So, Mr. Wade, do you understand the question that I just asked?
What's the question?
The question is, did you discuss with Mr. Wakeford, or did you request from Mr. Wakeford to seek the waiver of privilege?
I don't recall how it came about.
Okay. This document here was another email to Mr. Wakeford that was part of that open records request that I referenced earlier. Same place we got the White House letter that I just showed you. This is an email from Mr. Wakeford dated March 14th, 2022 to a Miss Lori Baranek, I believe, perhaps is the pronunciation. Does that name ring a bell to you? Lori Baranek?
It does.
Who is Miss Baranek?
She's the person that this letter went to.
What does she do for a living?
I'm not sure.
What's an AUSA?
An assistant U.S. attorney.
Okay. And this is Mr. Wakeford asking the assistant U.S. attorney, I wanted to reach out to you, see if it might be possible for a couple of us from FCDAO to come up the road and sit down with you for a few minutes later this week, possibly Thursday. We anticipate we might have to make a few more TUI requests, and I thought it would be beneficial to have a conversation about that process. Just let me know if there's something we might be able to work out. Either way, we will see you on Monday at 1 Atlantic Center. The number below is my direct line. We've heard testimony before about the TUI requests that you all are working on. Can you just refresh the committee's memory what a TUI request is?
Just getting permission to talk to people.
Okay. And do you recall if you traveled to this meeting with Ms. Baranek?
I don't recall specifically being there, but I can say that if it was a meeting, I was there.
Okay. Do you know what the meeting is here that's referenced Monday at 1 Atlantic Center?
Well, wait just a minute. That gets into a process and deliberation of the investigation. Do you know what the meeting was about?
No, I asked if you remember. Do you remember attending a meeting? I'll clarify that. Do you remember attending a meeting in March at 1 Atlantic Center?
Again, I don't recall specifically attending the meeting, but if the meeting occurred, I was there.
Okay. So she's with the Department of Justice. This is another email from the Department of Justice to Mr. Wakeford. I actually don't see a date on this one here, but the headline here, heading on the second one does show us that page. Show us the date of May 1st, 2022. It's just a couple months after the last one. This one here is from Mr. J. Macklin. Do you know who Mr. Macklin is?
I do not.
Okay. This says, we write in response to your April 19, 2022 letter, Civil Chief Lord Baranek requesting the DOJ's authorization to interview 5 individuals in conjunction with the Fulton County District Attorney's Office. And it says, it goes on to list former Attorney General William Barr, Acting Attorney General Jeffrey Rosen, former Acting Deputy Attorney Gerald Donahue, former Assistant Attorney General Stephen Engel, and Inspector General Michael Horowitz. Were those all individuals that you interviewed?
I don't recall.
Do you recall if you interviewed Bill Barr?
I don't recall.
Okay. Is there any individual on that list that you recall interviewing?
I guess what I'm communicating to you is we could have interviewed all, none, or some of them. I have no independent recollection of any of these people.
Okay. This is an email from Michael Hill to a redacted individual here, but appears to be Miss Alexis Hunter. Who's Michael Hill?
He was a former investigator with the Fulton County District Attorney's Office.
Working as part of the team that you were leading?
Yes, sir.
Okay. Was he the investigator that traveled to D.C.?
I don't recall if it was this investigator or some other one.
So he identifies himself as senior investigative officer. Our office is currently engaged in ongoing investigation. As we discussed, my team and I would like a brief audience with Congressman Thompson related to the aforementioned subject matter. Please forward this communication to Mr. Thompson. Email response comes from Mr. Tim Heapy, Investigator Hill. He identifies himself as Chief Investigative Counsel for the House of Representatives Select Committee to investigate Jan 6. We call that the Jan 6 Committee. I understand you reached out today to some or all members of the Select Committee seeking information about our interaction with 2 particular witnesses. Do you know who Mr. Tim Heapy is?
As I recall, Mr. Heapy was one of the lawyers that was in communication with us.
One of the lawyers for the Jan 6 Committee?
Again, I don't know that he would have been characterized as such, but Mr. Heapy and this young lady were associates of some sort.
Okay. Did you ever meet with Mr. Heafy?
Yes.
Okay.
I just want to say something about the process. You don't meet with a committee when you go to DC. When he's referring to the select committee, there's independent lawyers that they bring in, various people. You don't know, just because it's on somebody's signature line, you don't know what role they're actually playing with it. So there's layers to these things, and there's nobody that just represents the committee that's a job in itself. These are independent folks that move in and out. There's different layers of all this stuff. So it's very hard to answer questions. When he's talking to people, they don't have defined roles, even though they may say that on some letterhead or some signature line. It's not as clear cut as it would seem. So.
And the other question I have an objection is, how is this relevant to proposed legislation? In other words, the January 6th committee overseeing the coup that was encouraged by President Trump, and that's going to be a matter of legislation for the Georgia General Assembly?
Well, Governor, you were a member of the General Assembly. As you know, we can write all sorts of pieces of legislation that endeavor to do various things.
I saw them during the time.
So your objection, let's just clarify, your objection is on scope?
Beyond the scope, because it can't be the subject of legislation that has occurred in Congress. You're asking about a congressional committee.
I'm asking about
One that investigated the overthrow of the United States government. It's the worst thing I've ever witnessed in my lifetime.
Mr. Evans just told us that we can't be sure exactly who this individual is working for, so that's what I'm trying to get to. And then we'll get to the travel in a second. But he identifies himself as Chief Investigative Counsel to the Jan 6 Committee. His subject, or I should say his signature line identifies himself as the same, and he references that you all were seeking information about interaction with two particular witnesses. I think, Counselor, it's probably safe to assume that's in the context of the Jan 6 Committee and the Trump election interference case. But just to clarify that, Mr. Wade, do you recall who the two witnesses were that Mr. Heafy references that you guys, your members of your team had reached out to some or all members of the committee seeking information on?
I do not.
Wait just a minute. Only if they were publicly available. You can't, if it's part of witnesses that were never disclosed, then you put them at risk of harm, and not only that, it's part of the deliberative process. I mean, after Fani Willis testified, the number of threats that y'all compelled her to do, the number of threats increased to her.
This says here my colleague Dan George has been in touch with D.A. Willis about this matter, and we'd like to ensure continued communication as your grand jury investigation moves forward. Do you know who Mr. George is?
All right. Mr. George is in touch with D.A. Willis. I have no clue. I think she might be better served to answer that.
You don't recall talking to Mr. George, nor do you know who Mr. George is?
That's correct.
Okay. And this says we'd like to ensure continued communication as the grand jury investigation moves forward. This was in April of 22. I think you traveled up there afterwards, which maybe is the communication that they're referencing, but just want to get this, we'll get all the way to this in a second. I look forward to our discussion in the morning, and that's dated April 20 of 2022. There's an invoice here that you submitted that shows 4/18/2022 to 4/21/2022, team meeting, conference with Jan 6, research legal issues to prep interview. This is the one that we looked at earlier. Does this help you recall a trip to D.C. to meet with January 6th, the Jan 6 Commission?
No, sir.
Okay.
And that's what I'm asking.
And when you say it doesn't help you recall that, you're saying it doesn't help you recall if you travel there, it doesn't help you recall the actual content of the meeting?
Oh, I'm positive I traveled there.
Okay.
I just don't know when.
Okay. And these things are run together a little bit for me, but is this the meeting where the female individual, the attorney that you met with, was present?
I don't.
Yeah, just objection. We're getting into the process again.
On the presence of somebody we already discussed that he met with?
Yeah, well, he met with them, but I don't want to talk about people that he met with and name individual people.
We know that Mr. Dan George, you said you don't know who that is. Is Will Wooten someone that worked on your team, or is that somebody that did not work on your team?
He did, indeed.
Okay. And Mr. Wakefer, we know, worked on your team. And then Adam Nev,
Nay?
I'm not sure that's cut off or not, but is that an individual that worked on your team as well?
Yes, sir.
Okay. And then Ms. Trina Swanson Lucas?
Yes, sir.
Okay. So this email went to 4 or 5 of the folks that worked on your team. You're not copied on here. You probably don't recall if you see that email or not. actually, I apologize. I do see you on the bottom. I'm assuming that's you there. So your email address is redacted out, but it's got all one word with your name on it right there. So you actually were on this email. My apologies. We'll go to the next one here. This is after the trip. This is from Mr. Heapy again. Investigator Hill, it was good talking with you yesterday. I discussed your request for information with the committee, and I think we can accommodate to some degree. As we discussed yesterday, we're willing to provide an oral summary of what certain witnesses have told the committee in interviews and depositions. We are also prepared to give you access to some committee documents in camera in our office. And this was it would appear to me that this is exactly what the Politico was reporting on, that you referenced, that you had been to a meeting in D.C. where the female staffer was, the dates, the general time frame aligns, and obviously there's a discussion of evidence was given in camera. So I'll move on. I think we've covered that. This is an email from Mr. Hill back to Mr. Heapy again. It says, we'd like to, thank you for prompt follow-up. We'd like to confirm the meeting date, January 28th. We are currently confirming travel arrangements. And I think that's a different trip here that says travel out of state, interview and research. I think I asked you if you recall this conference. I'm not sure if that's a conference call or an in-person conference. Do you recall anything about this line item here, this travel out of state, that they were referencing in that email?
I don't.
Okay. Just a couple more here and I'm almost done. It says, this is an invoice from May 23rd, 2022. It says travel to Athens, conf with White House counsel. 8 hours. Do you recall a meeting with, or a conf with White House counsel?
I don't recall, but I'm looking at the invoices as you put them on the screen, and I'm looking at the numbers there, and those numbers are being used as if they are inflated somehow, or some large number that the county was being billed. And when I compare my invoices to those of the individuals who are requesting money from Fulton County, it pains me, because I'm looking at, for example, Mr. Cheeley's asking for $1 million, over $1 million. Mr. Eastman is asking for $800,000. Mr. Floyd, $900,000, $200,000, $1 million, another $1 million, $6 million, another $1 million, $900,000, $2 million. And these people, I investigated this case for almost 3 years, and the collective invoices for a period of almost 3 years doesn't add up to their 3 months.
I'm not sure what you're referencing for 3 months. I'm certainly not trying to say that anything here is inflated.
Well, what I'm referencing for 3 months is the total involvement of these attorneys' activity on this case, dealing with the investigative process, the grand jury process. They represented these people for a period of months. I represented the citizens of the state of Georgia for almost 3 years, and the numbers pale in comparison to what they're asking for.
Yeah, I know that, and I wasn't going to ask you what your normal hourly rate is, but you would seem to indicate earlier in your testimony that certainly is higher than this.
Much higher.
And that's fair. I'm not trying to get into what you charge here. I'm just trying to kind of fully understand who was involved, who the conversations were with. So I apologize if the Reddit line around the 2000 gives you the impression I'm trying to highlight that. I'm trying to highlight what's to the left of that. So you indicate you don't recall traveling to Athens.
I recall going to Athens. I do. I just don't recall when or what the subject matter was. Or
Do you recall who you met with there?
I don't.
Do you recall in the course of the investigation anyone that you came into contact with that would be described as White House counsel?
No, sir. It could have possibly been the reference from the letters that you just read, the young lady that we mentioned earlier, and or the latter, which was Mr. Heapy. So it could have been.
Okay.
And we're speculating. I don't recall from two.
I'll get the hourly rate, or I'll get the hours off the screen here for you, Mr. Wade, because it's really not my focus. Last one I wanted to ask you about, this is in September of 22, spans a couple of days, and it says witness interviews, conf call DC team meeting. Do you recall who you would have talked to?
No, sir.
In DC during September 22?
No, sir.
Who'd you talk to on September 22nd?
Well, if you put an invoice in front of me, Governor, I might be able to recall. And certainly, I've been to the White House one time in my life, and I can tell you who I met with. I remember walking in the Eisenhower office building. Remember the guard shack outside where I had to go through security. Remember seeing the store where you can buy the souvenirs. Remember that it was closed that day.
It says MAGA hat.
I didn't get to get into it because it was closed. But what I can tell you is, for me, I'm just a lowly state senator, but when I've gone to D.C. to meet with people, even a couple years later, I certainly can recall it.
Well, you make reference to going to the White House, sir. I didn't go to the White House.
Have you been to the Eisenhower office building?
I didn't know.
Okay.
I mean, I've read you, I've listened to your speech. I wish you would waive the speech and debate clause immunity, but I've listened to your speech. It's ridiculous that there was some kind of coordination. Do you believe that
We're not going to get into what I believe. We'll move on here. I want to make sure we stick to the time that y'all want to stay with.
We're replaying something from the.
Now, I'm just asking a question due to the billing. Mr. Wade, is there any reason to believe that any of this billing would be inaccurate?
You said I'm going to object to the relevance, because you said the billing was reasonable. That's the basis of this resolution, not to retry.
Oh, I don't believe I said anything. I don't believe I characterized the billing at all. I think I just said that wasn't the focus of my question.
Well,
and that Mr. Wade had testified earlier that his normal hourly rate is higher. And so I want to clarify with him that I was not trying to characterize anything relative to his hourly rate in either direction, but was more so trying to get to who may have been at these meetings. So
but
my last question on the...
That is the basis of this, not the fact that that President Trump committed a crime in this jurisdiction and was presented to a grand jury. So I object to the relevance of going forward.
Governor, your objection's noted for the
All right,
record.
thank you. Go ahead.
All right.
Waive speech and debate, we can let.
I don't even know what that is, Governor, but...
What you can't be sued for what you say from the Senate.
Well, I'm happy it's there then.
Then a jury can determine.
Governor,
whether it's
respectfully, we
or malicious.
appreciate the commentary. We've noted your objection for the record. We'd like to move on if we're going to have any semblance of keeping this within any reasonable time
Well,
period.
I didn't say a word for an hour and 20 minutes.
Come on now.
That's not true.
I don't know if it's ever been true besides the times we've been asleep. There is one more meeting I wanted to ask you about, Mr. Wade, that was not on these billings. I did want to clarify. You and I were talking over each other when Governor Barnes was talking. I assume it's your testimony here today that as far as you know, your billings are accurate and there's no reason to believe that anything is inaccurate. Is that correct?
That's correct.
Okay. Do you know the name Matthew Colangelo, individual who worked at DOJ?
I don't.
Okay. He worked at DOJ and on the 18th of November left and ultimately would end up working with Alvin Bragg. Does that help?
No, sir.
You recall who he is? You obviously know who Jack Smith is. I think everybody at this point is a household name.
Yes, sir.
He was appointed as special prosecutor the same day Mr. Colangelo appears to have tendered his resignation. And that was November 18th of 2022. Have you ever met with or talked to Mr. Smith?
No, sir.
Okay. Did you ever meet with or talk to any members of Mr. Smith's team?
No, sir.
Okay. There's a... Should I get this last one on the screen here? So November 18th of 2022 that I just mentioned is the date that Mr. Smith was appointed. And you show here an interview with D.C. White House on the 18th of November, that same day. Do you recall having a phone call with D.C. or the White House on November 18th?
I do not.
Do you know from this billing whether an interview would have been in person or via Zoom or over the telephone? Did you have any billing practices where if you did travel, you'd state it specifically as travel?
Yeah, I don't recall whether it was in person.
Okay. There's another one on there that is not on the 18th, just a couple days forward. It just says Jan 6 meeting and attorney conf. Do you recall what that is?
I don't. I mean, there seems to be a lot of attention being placed or a lot of focus being placed on external assistance. I know that it might be hard to believe, but D.A. Willis and this little team did the work. She led us, I led the team, and we did the work. We didn't get assistance, motivation, or however you want to characterize it. But they didn't. No one held her hand and guided her through the process. This is her work.
She did ask for assistance, though, and that was one of the very first slides I showed you, where she reached out to Mr. Thompson and specifically asked for that assistance. So that's just what we're trying to understand. But that really gets to the end of the questions that I had. I did want to turn it over to Leader Jones, then I'm going to need a bio break when you're done, and we'll come back and wrap up.
Thank you.
Let me get your mic on there, young man.
Thank you, Mr. Wade. I just have a few questions. And this would come from the public record out of the indictment. So this is all public right now. As for any kind of personal conversations. If I'm reading it correctly, I just want to go over a few things, kind of encapsulate it. If I'm reading it correctly, would it be accurate to say that what you guys were looking at, was just looking at the indictment, I was looking at that and trying to extrapolate here, was a pattern of conduct by the conspirators that basically would be like this: call elected officials, claim fraud that they weren't even claiming, ask them to then call a hearing. At the hearing, then make various wild speculative things that they knew were not true. And then at that point in time, ask those same elected officials to have fake electors basically be appointed at some point in time. And so in each state, would it be accurate to say that's kind of like the process that would take place?
Based upon the charging document, I would say yes, that's fair.
And with that, when they would go to these hearings, these different conspirators go to these hearings, many times would it also be accurate to say that they said things that they knew were not actually true. So for instance, when it came to Georgia, for instance, one of the things that was mentioned was Atrium County in Michigan, where they said, one of the conspirators basically said that the voting tabulator had tabulated wrong and gave Biden votes that were Trump. But wasn't it not accurate that the clerk in that particular county had already said, it wasn't a tabulation issue, it was my issue, I had done something wrong. And that what you see in state after state is where these people go to these hearings and say things that pretty much know were not true, but present them as facts. Would you also say, just based on the indictment, that is a kind of a path that you can see?
I would say that happened in Georgia.
Thank you. Also, when you start talking about how many persons actually pled guilty in Georgia?
4 of them?
And one name that also, I don't think pled guilty in Georgia, but one name that also comes up is a person by the name of John Eastman. And by your own personal recollection, I guess just for your own knowledge, do you know whether Mr. John Eastman, who is the president's attorney, has now been permanently disbarred because of certain things that he gave to the president as far as not certifying elections, certifying the 2020 election?
The extent of Mr. Eastman's involvement, I couldn't pontificate about. I'm not sure, but I do know that he's been disbarred.
And would you also agree, just looking at the indictment here, that the way this is kind of structured, the scheme was structured, just based on the indictment, that you needed to have the states, these 6 states basically, Georgia being one of them, you needed that basically bring their elections into doubt to where that then would fit any type of recommendation not to certify the elections on the federal level. So in other words, each part of the scheme was, let's bring the state elections in doubt, and therefore we can connect it and say, hey, Vice President Pence, do not certify. Was that part of this?
I'm going to have to not answer that question because I think it would comment on touch on areas that I'm not allowed to address.
Okay.
You mind sliding that microphone just a little bit closer to you, or just raise your voice a little bit?
Sure.
Thank you.
And one of my final ones, actually, just judged by the indictment, which is in here, these 2 organizations are actually listed. Anybody who went to these hearings and talked about sort of these wild kind of schemes or these things trying to bring the election to in doubt, they also would have been flying in the face. I think the indictment talked about the fact that 2 federal agencies on November 12th had already said that the election was actually clean and it was fair and it was a good election. And that these people who many work for the federal government would have been aware of those agencies saying that. Is that basically correct?
Yes, sir.
Okay. I don't have anything further.
Thank you, Mr. Leader. Chairman Cowser, did you want to? You're on 6.
Couple if you'll allow me to.
You're recognized.
So thank you for being with us here today. Prior to this case, had you ever served as a special prosecutor before?
I served as a special assistant U.S. attorney.
What type of case was that?
It wasn't a case.
Just an investigation? Had you ever prosecuted a felony offense before this case?
Prosecuted or defended?
Prosecuted.
Again, in my open, I indicate that I've defended cases ranging from murder on down, murder,
Yeah.
rape, robbery, aggravated assault. I've defended all those cases. I know from the hearing, the disqualification hearing, the way that I was painted was as if I had no trial experience or wasn't even familiar with the courtroom. Quite to the contrary. I've defended lots of cases all over the state.
You just had never prosecuted before?
I had prosecuted.
Felonies?
I'd never prosecuted this type of case. In fact, no one has.
Yeah. Any involvement in RICO?
And no one has ever defended this case.
Any involvement in RICO
No, sir.
prosecutions before?
No, sir. I got all my training at that time.
Okay. And would you mind putting into evidence with us the letter to you from D.A. Willis intimidating you from revealing any details about your case? Because that's why you have not been free to tell us.
I didn't have an
details.
intimidation letter, but I wouldn't mind putting the letter that I read into the record.
Right. It's the one that reminded you that you can't say anything
Yes,
about
sir.
your prosecution. Okay. What was your reaction to the fact that the judge ultimately dismissed this case that you brought as groundless? unsubstantiated.
Wait, so that's not what he said. He didn't say it was
Just
wrong.
let him answer
And I
if he-
object to
yeah.
the characterization.
Well, I object to you saying it's the greatest coup in history on January the 6th,
So you're
and that's your
defending-
personal opinion,
So you're
you know.
defending?
They're fighting.
You're defending what happened on January
If you could either answer my
6th?
question or state your objection, Mr. Wade.
And the president standing out there and saying, if you don't go up there right now, you'll lose your country, and hang Mike Pence, you're defending that?
You're free to have your interview with the press after this.
No, sir.
I'm trying to
I mean,
wrap up
that's
this
all matter
question,
of
and
a
you know.
record. And I just want to know, are you defending that?
I am not under examination from you, Governor. I know you're making your political points, and I hope you get your TV time from doing that. I just
All right,
need
gentlemen.
to answer this question.
Call this back to
Oh,
order.
we got a
Governor,
gavel.
your objection's noted for the record. Thank you.
What's your question, sir?
I wanted your reaction to the fact that the judge ultimately dismissed your case. After you guys have been disqualified, Pete Scandalakis end up
So
investigating.
I stand by the work that we did. You know, I doubt that anyone other than this team has had ample amount of time and opportunity to review all the evidence in this case. It is impossible to do that within such a short frame of time. So anyone who says that they reviewed this case in its entirety, they're not being forthcoming because it's not possible to do so. My reaction is I stand by our work. I stand by that indictment, and I'm very proud of the work that we did.
Thank you.
Any other questions?
Not from me.
Chairman, all right. Thank you.
That's
Harry, absolutely give leader the last word here on 9.
Yeah, but isn't it also accurate, there's actually other defendants that are still under indictment in other states, they're still pending, and they're with similar charges, is that not correct?
I believe so.
All right, thank you.
Anything further, Mr. Leader?
Nope.
All right, gentlemen, I do want to thank you for your time today, Mr. Wade. Thank you for appearing today. We didn't quite keep it to an hour, but we didn't let it drag on too long. Mr. Evans, thank you as well. Appreciate your wife's service to the state, and we will be adjourned for today.
He released him.
He is from this one, yes, sir.
From this one. He's released from this subpoena. All right. So, and if you didn't watch when Jim and I watched Fani Willis testify, I know it was like fiery. I know there was like, it was spicy. I just didn't think it was informative. I didn't think this was all that informative. I think maybe it's not so much about trying to get new information, but maybe a detail here or there that they're trying to nail down a contradiction. That seems to be the purpose of the question here with Nathan Wade, from my perspective. I thought hearing from Jeff DiSantis was quite a bit more interesting. Maybe it's because I'm interested in the intersection between like publicity, social media, maybe a little bit of astroturfing, viral reactions, and a little bit of news media too, and politics, and the way that a prosecution that's heavily politicized can be influenced kind of before the decision to start the investigation, all the way through till whenever it comes to an end, whatever that prosecution or investigation might entail. So to me, just personally, I thought that was more interesting to hear about and see some quantification of that data. And again, we did have qualification from, we saw it in the emails, not just from the testimony of Jeff DiSantis today, but also it was acknowledged by the senators that, you know what, like, yeah, these are estimates on value. We don't really know, like, money might be fungible. We could exchange something. We know that $10,000 for work was in exchange for a hard-lined expectation that something would be returned, like the service rendered. But these values on the publicity, the $150 million valuation on Fani Willis's name, because of how much is coming up in search results and how much things are being reshared that are mentioning her, that's just like something that's decided by this contracting company as an estimation of value. And I don't know if that type of work is going to become more sophisticated where they can put dollar amounts on that type of thing and get more precise. But I do feel like it's quite a ballpark estimation at this point in time. But I mean, the way, if somebody wants to climb the career ladder, would they take a certain prosecution? Something that I'm thinking about as a parallel is the resistance, in a way, that I'm seeing with the Holly Bobo case over in Tennessee. And now that's just dealing with district attorneys. It's not dealing with a case involving, it's not Young Doug, it's not Trump. It's just a high-profile case of a missing girl that is now in a post-conviction relief stage where Zach Adams' team is saying, hey, the district attorney is engaged in some foul play. And I think a big concern over there is the amount of attention that the post-conviction relief hearings got. It makes me wonder if that's going to play a role in, next time anybody's up for office, is the handling of the Holly Bobo case now going to come into play? And what are the ways that we can look at social media insights, the data, the analytics, the amount of times people are clicking, resharing, reposting, viewing certain content? And viewing doesn't necessarily tell you a sentiment. Resharing doesn't necessarily tell you a sentiment. So you have to do a little bit more research to see what the connotations of the online discussions are about. Is it in support? Is it neutral? Is it condemning the behavior? And how does that shape, in the big picture, will that shape a focus on these major prosecutions in the future? I don't know. I just think it's a lot more interesting than, I don't know. This is me personally. I think it's interesting to follow either way and see where this goes. So far, the only thing of significance that has come out from the investigative committee, because remember their purpose, not purchase. Their purpose is to decide, because this is legislative branch. Let's look at the legislation we have. Is it enough? Is it missing something? Is it overbroad? And so far, the only thing tangible that we have from this was Senate Bill 255, which increased the subpoena powers of the legislative branch. So, in short, it says a bill to be entitled to an act. It was entitled in May of 2025 to amend Chapter 1 of Title 28 of the Official Code of Georgia Annotated, relating to general provisions regarding the General Assembly, so as to codify a process for the authorization of statutory investigatory powers. So by statute, they would have the right, the authority to investigate to certain committees of the General Assembly, to provide for oaths and subpoena powers related to such investigatory powers, to provide for confidentiality of certain materials, to explicitly preserve any authority, immunity, privilege, or power granted to or possessed by the General Assembly or its members, to provide for related matters, to provide an effective date, to repeal conflicting laws, and other purposes. So it expanded the powers of the legislative branch here, especially in relation to these special committees, to where, hey, we can tiptoe over and have a greater power to check and balance what the executive branch is doing. Someone like a district attorney would fall under the executive branch. And that's really all we've gotten so far. But the purpose of these hearings, at least the stated purpose, is to decide, do we need to do more? Should there be statutory power that allows us to have more oversight over the hiring or usage of funds that would be allocated to the hiring of somebody like a special prosecutor, who kind of falls outside the range of a direct hire within the district attorney's office, which is part of the executive branch, and is rather a subcontractor? Does there need to be legislation that gives somebody an ability to do some oversight there and put a process in place? So, and I know that sounds convoluted because I think that's getting lost in the weeds because it's become so like you versus them, us versus them, tribal politicization within these hearings. And that's not that interesting to me. So if you're new to this channel, I hope you subscribe. We don't always look at like legislative stuff like this. I focus a lot more on the judicial branch. I like looking at trials. I like looking at appeals, especially. I love reading motions. I love reading depositions. Love it. So please hang out, hit the like button. The YouTube will do a good job if you hit the like button and subscribe, and you only really like the Senate committee stuff and Fulton County stuff. YouTube does a good job now of only showing you the topics from a creator that you want to see. It won't just flood you with everything that I do unless you start liking it. So hit that subscribe button, come get back together with us if there's another hearing in this matter or if there's anything else we do about Fulton County. Also want to give a shout out here to the World's End being a member for 17 months. That's a super long time. So incredibly grateful for, that's a long, long time. So thank you for your support. And with a nice message here of keep up the great work, Kat. And something that I think is more fun, right? We have this Afro Man lawsuit that we're going to be looking at. The trial is set to start next week. And this is a lawsuit being brought by police officers that are claiming defamation and a few other claims against Afro Man, whose government name is Joseph Foreman. When the police raided his home, he used security footage that he owned from his own cameras and created a music video with some of that footage, and also started selling some merch. But the sale of merch, the claims, the civil claims relating to the sale, the proceeds of the merch, have been dismissed. So that's not going to be at play in trial. It's really like defamation, invasion of privacy. We'll go over the remaining complaint on that stream. It's very interesting because these police officers are suing Afroman. The broad top-down level issue is that he's disseminating and using their likeness through what was in this surveillance footage that he recorded from his own property of them acting in their capacity as law enforcement officers. So in a way, to me, and not really in a way, in a significant way, even though they're suing in their individual capacities, it still seems like they're trying to pursue litigation to get somebody to shut up about their commentary about the government, law enforcement, which is something I find to be protected by the First Amendment, and maybe I'm missing something. So we're going to go look at the motions in limine filed by the plaintiffs in that case to keep the music video that they have an issue with out of evidence, which seems like a mess. So that's going to start in I'll probably move it forward. I'm going to take about 30 minutes to eat a sandwich or something and come back around. This will redirect you over there, so just hit the reminder and you'll see when it goes live. And other than that, I also did see the Fit Lawyer ATL and Jay Witt, I used to call him DWC. He renamed his channel, and I didn't know for the longest, but now he's the Jay Witt podcast. He and the Fit Lawyer ATL will be live tonight, just as a casual Friday stream, watching body cam videos. So they're going to do some reactions. We'll redirect from the Afroman stream to them. They're starting at 7 or 7:30 Eastern time. So hope to see you around. If I see you sometime in the future and not today, have a great weekend. Franju P. Diddy, member for 19 months. Thank you so much. Love your channel. Well, I love that you love this channel because I always love seeing the profile picture pop up. Always love to see it. So perfect way to send us off to the next stream, you guys. Everybody take your bio and or comfort break, and see you in a little bit. Thank you so much, you guys. Have a good one.